All rise.
The Kosovo Specialist Chambers is now in session.
Be seated, please. Mr. Court Officer, please call the case.
Good morning, Your Honors. This is the file number KCBC 2020-06, the Specialist Prosecutor versus Hashim Thaçi, Kadri Veseli, Recep Selimi, and Jakub Krasniqi. Thank you, Your Honors.
Good morning and welcome, everyone. I note that the accused are all present in court today. Today we will continue hearing the closing statements in this case. This morning we will start with the closing statements from the defense for Hashim Thaçi. Later today we will hear counsel for Kadri Veseli's closing statements. We will follow the agenda set out in the panel's order on the closing statements, which is filing F03639. Just as a reminder, today's hearing is scheduled to conclude at 16:45, and breaks are scheduled for half an hour at 10:30, resuming at 11. 1.5 hours for lunch at 1300, resuming at 14:30, and 15 minutes at 15:30, resuming at 15:45. Lastly, since the closing statements are being interpreted, the panel reminds the parties and participants to speak at a slow pace to allow for the interpreters to catch up. This concludes the remarks from the panel. We will now start with the closing statements of the defense for Hashim Thaçi. You have been allocated 4.5 hours, which means you are scheduled to finish by no later than 15:30 today. Mr. Mistich, you may proceed.
Thank you, Mr. President. Good morning to you, to our colleagues on the prosecution, and to everyone in and outside the courtroom. At the outset, we have hard copies of our PowerPoint presentation, which we would like to distribute to the panel, CMU, 1 copy to the prosecution and 1 copy to Victims' Counsel, with your leave. While that's being distributed, we will put on the screen a roadmap of our presentation so you know what's coming and who's coming. I will start with the introduction, then I will address, was there a joint criminal enterprise? I will address the prosecution's allegation that Mr. Thaçi was a member of the joint criminal enterprise. I will address the prosecution's arguments about Mr. Thaçi's alleged command position. I will then turn the floor over to Ms. Tavakoli, who will discuss the provisional government of Kosovo not being a significant contribution to the alleged JCE. Co-counsel Ambassador Prosper will then address the issue of the Specialist Prosecutor's Office attack on defense witnesses. I will then return to address law and evidence, and then finally sentencing. And that will conclude our presentation. Your Honors, let me start by saying this. Hashim Thaçi is innocent. That is your starting position as you commence deliberations. We know he is innocent at this point in the proceedings because the law requires you to presume that he is innocent. Believe it or not, I have heard presidents of international criminal tribunals give speeches where they get this wrong. They say, a finding of not guilty does not mean we said they were innocent. That kind of thinking misunderstands what the entire process of international criminal trials is about. You have before you 4 men whom the law says you must presume to be innocent. These proceedings have been brought because the Specialist Prosecutor's Office has come forward and made the claim that they have evidence that proves beyond any reasonable doubt that they are guilty. And so, for over 5 years now, we have been engaged in a process designed to put the Specialist Prosecutor's Office to the test and to see whether they can prove their allegations. This trial is therefore not an examination of the life of Hashim Thaçi. It is a test of the SPO's claim that Hashim Thaçi should no longer enjoy the presumption of innocence. When you commence your deliberations, you will start from the position that Hashim Thaçi is innocent, and then you will assess whether the evidence presented by the Specialist Prosecutor's Office has convinced you beyond any reasonable doubt that Hashim Thaçi is guilty. If the SPO has not convinced you, if you conclude that there is at least one reasonable explanation of the evidence other than that Hashim Thaçi is guilty of the charges in the indictment, then you are required to find that the SPO has failed and enter a judgment of acquittal. Hashim Thaçi will remain innocent as a matter of law. Slide 5, please. We submit that in your deliberations, you will come to the inevitable conclusion that the SPO cannot meet its high burden of proof. The totality of evidence demonstrates a consensus of international witnesses, insider KLA witnesses, and documentary evidence which establish reasonable doubt about the SPO's allegations. And so the record is clear, I want to say at the outset, the SPO has made no allegation that any witness in this trial was interfered with. Let's first look at the international witnesses. You heard from numerous international witnesses that Hashim Thaçi was not suspected of involvement in war crimes as these events were unfolding. These international witnesses told you that they were, in fact, informed about events on the ground through diplomatic, intelligence, and other sources, as well as their own personal experiences, including their experiences with Hashim Thaçi. You heard this, for example, from the former Assistant United States Secretary of State, James Rubin, who told you that in late June 1999, he specifically investigated claims made in the New York Times in June 1999 about Mr. Thaçi, checked all available intelligence sources, diplomatic sources, the Human Rights Division in the State Department, and other information available to the United States government, and could not find any evidence linking Mr. Thaçi to war crimes. You heard from the former NATO Supreme Allied Commander of Europe, General Wesley Clark, who told you that he does not believe it would be just to attribute the misconduct of others to Hashim Thaçi, and that he knows of no evidence that he personally committed any violent act or ever worked with others to do so. You heard from the UN's Principal Deputy Special Representative of the Secretary General, Mr. Jack Covey, who was on the ground and who told you that based on his personal observations, Mr. Thaçi was not in a position either to organize the interethnic violence that engulfed the country during the summer of 1999 or to summarily call it off, and that he, quote, observed and otherwise knows of Mr. Thaçi on multiple occasions taking great risks by emphatically and repeatedly denouncing that violence and by strongly advocating multi-ethnic tolerance. You heard from experienced and distinguished U.S. diplomats like Michael Durkee and Sean Burns and Christopher Hill, who described Mr. Thaçi's role in the KLA as akin to a foreign minister. Ambassador Hill told you of his vast experience dealing with international leaders and personalities across many decades of diplomatic service, and he formed the view that Mr. Thaçi was, quote, not the type of person to commit violence against others. You heard from an experienced and distinguished British diplomat, John Duncan, who told you that Mr. Thaçi could not have independently stopped the violence in the summer of 1999. And you heard from the respected professor of international law, Paul Williams, who was a trusted advisor to the Albanian delegation at Rambouillet and who observed Mr. Thaçi's interactions from inside the delegation and concluded that Mr. Thaçi did not have the authority inside the KLA to make decisions on his own. The SPO tries to dismiss the testimony of these international witnesses as people who were simply uninformed about the inner workings of the KLA. For reasons I will discuss later in this submission, the SPO's claim that international witnesses were uninformed is peculiar, given the centrality of KLA communiques, political declarations, and media interviews to the SPO's case that the alleged common criminal purpose was communicated to lower levels of the KLA through such public documents. Slide 6, please. We heard the SPO on Monday say that the opponent policy was, quote, openly articulated and actively implemented. All of these public documents would have been available to Sean Burns and the defense's international witnesses and their countries and international organizations, and would have informed the views of the international witnesses. Moreover, the evidence of these international witnesses is strongly reaffirmed by the testimony of senior KLA officials, insiders from whom you heard and who took the same view as the international witnesses. And they also told you that Hashim Thaçi had nothing to do with any alleged policy to target so-called opponents, to detain civilians, or to mistreat them. You heard this from Commander Rustam Mustafa Remy. You heard this from the Deputy Commander of the KLA, Sokol Bashota. And most importantly, you heard it from the Chief of the General Staff himself, Bislam Zarapi. Slide 7. And on this slide, you see the testimony of Bislam Zarapi, who confirmed for you that he was not aware of a General Staff policy to target collaborators or any involvement of Hashim Thaçi in any such policy. Quote, question, were you ever aware of any agreement, spoken or unspoken, within the General Staff of the Kosovo Liberation Army in which Mr. Thaçi was involved to abuse the human rights of either collaborators or people perceived to be opponents of the KLA? His answer, no, I wasn't. Question, were you ever aware of any agreement, spoken or unspoken, to unlawfully intimidate people perceived to be opponents of the KLA or collaborators, or to commit violence against them, or to remove them so that the KLA could seize power in Kosovo? His answer, no, I wasn't. Slide 8. I will discuss Bislam Zarapi's evidence and the SPO's treatment of his evidence in a moment and in some detail. But for now, I draw your attention to the SPO's assertion on Monday, where they described Zarapi as, quote, the one General Staff member who did not form part of that group of trusted persons. He was the only outsider. That's a transcript 28468. Slide 9, please. This is consistent with paragraphs 1431 and 1432 of the SPO's final brief, wherein the SPO asserts that Zarapi's past and present testimony has been, quote, broadly consistent, close quote, but tries to dismiss his exculpatory evidence for Mr. Thaçi on the basis that he was allegedly, quote, not part of the General Staff inner circle to which the accused belonged, close quote, and was, quote, not fully trusted by all KLA members, including certain members of the General Staff, close quote, and therefore, quote, such factors would affect the extent to which the JCE members would openly discuss opponent policy with him. The SPO goes on to assert in paragraph 1433 that Zarapi, quote, has given largely consistent evidence over time before different courts and stood behind those statements. This is consistent with the way the SPO has pleaded its case, namely, at no time has the SPO identified Zarapi as a named or even suspected member of the alleged JCE. In summary, the SPO's position is that Bislam Zarapi is generally a credible witness. He was not identified as part of any JCE and is not alleged to be by the SPO. The SPO's case is that those who were JCE members kept discussions of their criminal purpose from him. The SPO's position on Zarapi has significant implications on the overall credibility of the SPO's case. Why? Slide 10. Because for most of the indictment period, Zarapi was either the head of operations of the KLA or the chief of the general staff. He was therefore at the very center of the KLA's operations. He went out into the zones and was with Mr. Thaçi when Thaçi was in the zones, including near Rahovets in July 1998, in the Shala and Lap zones in August 1998, and in the Dukagin zone in September of 1998. You see that on your screen. The SPO final brief argues that all of these visits to the field by Mr. Thaçi and others were for the purpose of conveying and implementing the common criminal purpose. Slide 11. And yesterday, you heard Mr. Halling cite P00607, a newspaper interview given by Mr. Zarapi, which the SPO bar-tabled and which was never shown to Zarapi by the SPO for comment. The SPO quotes the newspaper article in support of the claim that Zarapi had sought the consent of Thaçi and Veseli in order to install men who would oversee, in the words of the SPO, a torture operation. Slide 12. We are, of course, prejudiced by the SPO's failure to put this argument to Zarapi or anyone else. But how does the SPO reconcile its position that Zarapi was not a named member of any JCE, not trusted by the JCE members, with the fact that Zarapi traveled with Mr. Thaçi to each of these visits and not only attended, but participated in the discussions? How does it reconcile its position that it was Zarapi who installed men operating a torture operation with its argument that Zarapi was not in the JCE and not trusted by the JCE members? Slide 13. How does the SPO reconcile its claim that Thaçi implemented the common criminal purpose in these meetings in the field with Bislam Zarapi present for all of them, with its position that Bislam Zarapi was not a named member of the JCE and the so-called JCE members tried to conceal the common criminal purpose from him? The SPO does not say. And this is a common problem throughout the SPO final brief and its closing statements. They simply ignore all of the trial evidence that discredits their case. The Chirz video is but one example, which I will get to later. Reviewing the SPO final submissions is like reading a movie review written by someone who didn't watch the movie. Slide 14. Zarapi testified that in these visits to the zones, he had heard complaints about treatment of prisoners within the zones, and this was the reason that he issued orders in November 1998 as chief of the general staff to try to put a stop to any mistreatment of persons. His testimony is corroborated by the contemporaneous written order, which you have in evidence as Exhibit 1D29. The SPO final brief does not challenge Zarapi's evidence on this point, or that his order 1D29 was made in good faith. Indeed, this order corroborates the agreed position of the defense and the SPO that Bislam Zarapi was not a member of the alleged JCE. While we were on the order, you heard Mr. Tiger on Monday suggest that the 28 November 1998 order was understood not to apply to collaborators because they weren't deemed to be civilians. And that's at transcript page 28400. However, this is not what the SPO said in its final trial brief. As you see on this slide, in paragraph 871 of the SPO final brief, the SPO refers to general staff orders to detain collaborators. And if you look at the documents cited in the footnote, 1D29 is one of them. Slide 16. Zarapi also confirmed in both his SPO interview and his trial testimony that the order applied to collaborators as well, and that's on your screen as well. Slide 17. But even looking at the order, there is nothing to suggest that it excludes collaborators. I draw your attention to paragraphs 1, 3, and 4 of the order. Paragraph 1, stamp out the negative phenomena and abuse against persons. The same in paragraph 4, referring to the arrest, detention, or imprisonment of persons. The words there do not say civilians. When the order wanted to refer to civilians specifically, it did so expressly, as in paragraph 3. Slide 18. So how does the SPO reconcile its position that Zarapi, the chief of the general staff, was issuing orders that allegedly were at counter purposes to the alleged common criminal purpose of other members of the general staff? Why would the JCE members allow him to obstruct their criminal objective? Again, the SPO does not say. We say that 1D29, issued by someone at the very heart of the KLA's operations, establishes a reasonable interpretation of the evidence that there was no JCE involving the general staff, as alleged by the SPO. Slide 19. Another problem that Zarapi poses for the SPO concerns the SPO allegation in its final brief that certain directorates of the general staff were instrumental in implementing the common criminal purpose, including the Civil Administration Directorate, the Military Police Directorate, and the Personnel Directorate. However, all of these directorates were subordinated to whom? To Bislam Zarapi as the chief of the general staff. You see here on this slide an organogram of the general staff which the SPO showed you on Monday. You see here that these directorates are alleged by the SPO to have been directly subordinated to Zarapi. You see here that they are not alleged to have been subordinated to Mr. Thaçi. You should also note that the SPO confirmed that in addition to the accused, those in the black boxes are alleged JCE members, and those that are not in the black boxes are not alleged to be JCE members. Zarapi is one of those not alleged to be a JCE member. Slide 20. The SPO also noted during their closing statement that Zarapi was receiving reports from the zones about special warfare. However, their position is also that Zarapi was not in the JCE. Slide 21. So how does the SPO reconcile its position that multiple directorates of the general staff were implementing a common criminal purpose, even though the person responsible for leading them was not alleged to have been? And how could he have been unaware of such a criminal purpose if they were directly subordinated to him? Slide 22. The next issue for the SPO concerns its repeated claim throughout its final brief that the general staff made its decisions collectively through a collective decision-making process. See paragraphs 64, 103, 113, 471, 480, 481, 504, 512, 515, and 612 of the SPO brief. Indeed, in paragraph 64, the SPO asserts it relies on the 2006 ICTY statement of Sokol Bashota for the claim that, quote, there was a collective decision of the general staff authorizing further measures for collaborators. The SPO's case is that general staff reached decisions collectively, including in the case of collaborators. Slide 23. The SPO's case also does not allege Zarapi, as chief of the general staff, to have been a JCE member himself. In their final brief, the SPO has clarified further that Zarapi was allegedly not part of the general staff inner circle to which the accused belonged and was, quote, not fully trusted by all KLA members including certain members of the general staff, and therefore such factors would affect the extent to which the JCE members would openly discuss opponent policy with him. As noted earlier, this has now also been confirmed in the closing statement. Putting aside for a moment the lack of credibility of the Bashota 2006 ICTY statement, which I will address later, the SPO, by acknowledging that Zarapi was not a JCE member, necessarily acknowledges that collective decision-making, even in the case of collaborator policy, does not automatically put every general staff member in the JCE. Otherwise, the SPO would have identified Zarapi as a JCE member, especially given he was the chief. Slide 24. If leadership of the general staff does not automatically make Bislam Zarapi a JCE member, as the SPO acknowledges, then mere membership in the general staff cannot make Hashim Thaçi a JCE member either. Slide 25. The SPO stated on Monday at transcript page 28366 that there can be no conviction on the sole basis of being a member of the general staff. We agree. Slide 26. You may be saying to yourself, well, Mr. Mishetic, what about the documentary evidence? Maybe these international witnesses were unaware of the smoking gun orders from Thaçi to beat and kill opponents. But there are no such documents implicating Thaçi. There are no general staff orders in which detention and mistreatment of so-called opponents is suggested. And the SPO does not claim otherwise. On the contrary, the only order on the issue of civilian detention is the one I've mentioned, 1D29, where Zarapi ordered the proper treatment of persons. There are no orders in the record from Thaçi to perpetrators of crimes. There are no reports from perpetrators of crimes to Thaçi. There is no credible evidence that Thaçi authored communiques, or let alone that he authored any inflammatory communiques. There is no credible evidence that any KLA communiques significantly contributed to any of the crimes charged in the indictment. And there is no credible evidence that he was personally involved in the commission of war crimes. And I will address this point a bit later in my submissions. Slide 27. The SPO asks you, the trial panel, to thread an incredibly small eye of a needle. They ask you to find that there is no reasonable doubt of the existence of a joint criminal enterprise in 1998 and 1999 within the KLA General Staff, in which Hashim Thaçi was a participant, a JCE which committed war crimes and crimes against humanity in order to, quote, gain and exercise control over all of Kosovo, but also ask you to find that it would not have been evident to international officials and the NATO countries which intervened militarily on the side of the KLA. The SPO asks you to make the finding that the JCE would not have been evident even to the Chief of the General Staff. And it asks you to make this finding in the absence of any internal documents where any such plan to target so-called opponents for the purpose of gaining and exercising control over all of Kosovo was ever suggested, let alone discussed. There are not even any books, memoirs, or manuscripts where any such plan is recollected. In the words of General Clark, the SPO asks you to find that this was quite the elaborate deception. Slide 28. The SPO effectively asks you to tell the world that you are going to rewrite the history of the Kosovo War based almost exclusively on inference, because there is no direct evidence supporting their allegation of a common criminal purpose. And they ask you to draw these inferences after a trial in which the SPO was too afraid to put its theory to a single witness, whether called by the SPO or the defense. The SPO's fear, and I don't use that word loosely, its fear of putting its case to any witness in this trial is an admission of what the SPO thinks of its own case, of its own lack of direct evidence to confront witnesses who dispute their case. Slide 29. Until now, the jurisprudence of international courts and tribunals has found that NATO intervened militarily in Kosovo in 1999 in response to a Serbian JCE that began no later than October 1998. The SPO is asking you to find, on inference alone, that actually it was the KLA that had plotted a joint criminal enterprise months and perhaps years earlier, but no later than March 1998. Moreover, the jurisprudence of the ICTY has established that the Serbian political leader, President Milan Milutinović, was not criminally responsible for the events in Kosovo in 1998 and 1999, precisely because he was a political figure who did not have effective control over FRY forces and therefore did not make a significant contribution to a JCE. The SPO asks you here to find that although the Serbian president of an organized and well-established state was not criminally responsible for massive war crimes and crimes against humanity due to his lack of effective control, you should, on inference alone, find that the Kosovo Albanian political leader of the KLA, a non-state armed group only months in existence, had effective control and was criminally responsible. That result would be a perversion of history and a legal and historical injustice. Slide 30. Your Honors, the SPO's case is not the only reasonable interpretation of the evidence, which is the standard that must be met in order for you to rewrite the history of Kosovo in this case and to convict Hashim Thaçi. There is ample reasonable doubt for you to enter a judgment of acquittal on all counts. I will turn now to the section, was there a JCE? Slide 32, please. At the core of the SPO's case is its central allegation that there was a common criminal purpose to, quote, gain and exercise control over all of Kosovo through the commission of war crimes and crimes against humanity. As I've said, the SPO asks you to find beyond any reasonable doubt that such a common criminal purpose existed based purely on evidential inferences. There is no direct evidence that any such plan ever existed. No evidence of any meetings where any such purpose was discussed. No documentary evidence of any such purpose having been agreed or discussed. No witnesses testified to the existence of any such purpose. Indeed, every witness who had an opportunity to address the issue denied the SPO's theory. Even worse, the SPO never put its case to witnesses. The SPO's claim on Monday that it is using direct evidence in support of its case reflects a fundamental misunderstanding of what direct evidence is. Direct evidence is evidence that proves a fact in issue without the need for any intervening inference. What is the direct evidence of a common criminal purpose which was unknown to Zarapi and the international community? Next, the SPO cites no evidence of General Staff meetings where the common criminal purpose was agreed or discussed. And the SPO makes no claim in its brief that Thaçi ever attended a General Staff meeting where targeting of opponents was discussed. Slide 33. The SPO makes the sweeping claim at paragraph 75 of its final trial brief that, quote, opponents and special warfare were discussed on a recurring basis at General Staff meetings. But there is no discussion in the SPO's brief about any such meetings. the SPO leaves it to the trial panel to dig into the footnotes and retrieve the cited documents in order to discover what meetings the SPO is talking about and what was discussed in those meetings. And when one checks those footnotes, one sees why the SPO avoided any substantive discussion of KLA General Staff meetings. Slide 34. For example, in footnote 283, the SPO is only able to identify 2 meetings where it claims opponents and special warfare were discussed. A meeting on 16 August and another on 29 December. Slide 35. The August 16 meeting was a meeting where there was a very specific discussion about the KLA being targeted for takeover by Tahir Zemai and FARC. First, the SPO has not established that Mr. Thaçi was even present at this meeting. Indeed, the SPO final brief makes no claim that Mr. Thaçi was present at this meeting on the 16th of August. And you see the testimony of Bislam Zarapi there on your screen, both from his SPO interview and his trial testimony, where he confirmed that he was present for that meeting, but did not have a recollection of Mr. Thaçi having attended. The next slide is not for public broadcast. Slide 36. Second, the panel has seen evidence that it was not the KLA that targeted Tahir Zemai, but rather Tahir Zemai and Buyar Bukoshi, who had targeted the KLA to have Bukoshi take over control of the KLA. There is nothing in the evidence to suggest that there was any discussion of a broader policy to target so-called opponents in order to gain and exercise control over all of Kosovo. This next slide may be broadcast for the public. Slide 37. The second meeting the SPO cites is a 29 December meeting, which Mr. Thaçi did not even attend because he was out of the country, and the SPO does not allege that he attended the meeting. Accordingly, the SPO in its final trial brief has not been able to identify a single meeting of the General Staff which it alleges Mr. Thaçi attended and where the topic of opponents or special warfare were ever discussed. As an aside here, Your Honors, let me remind you that the SPO on Monday told you that Sokol Bashota's 2006 ICTY statement, in which he is recorded as having said that the General Staff would collectively issue an order to kill collaborators, was not hypothetical, as Bashota told you it was. I will address Bashota's 2006 statement a bit later, but for now, it is sufficient to point out that the prosecution has not identified any such meeting where any such discussion would have taken place. The only meetings the SPO cites are those 2, 16 August, 29 December. Slide 38. Your Honors, putting aside for a moment the fact that the SPO does not even allege Mr. Thaçi was present for either meeting, it is important here to contrast the SPO's claims that opponents and special warfare were discussed in the meetings of 16 August and 29 December with the SPO's position that Bislam Zarapi was an outsider, he was not a member of the JCE, was not trusted by the alleged JCE members, and that the JCE members would not openly discuss the so-called opponent policy with him. Slide 39. Zarapi told you he attended the 16 August meeting at transcript page 17389. You see that testimony on your screen. If Zarapi was present for the discussion, then there is a reasonable inference for you to draw that there was no discussion about gaining and exercising control over all of Kosovo through the commission of war crimes and crimes against humanity, in light of the SPO's acknowledgement that Bislam Zarapi is not alleged to have been a member of the JCE and would not have been involved in any such discussions. Moreover, the SPO asked Zarapi about a discussion at the 16 August meeting concerning the appointment of commanders and formation of brigades, but never asked him a single question about whether there was a discussion about targeting opponents at that meeting. The SPO cannot claim that Zarapi was not being candid about that meeting because of a, quote, climate of intimidation in Kosovo, if it never put its case to him about that meeting. Slide 40. Zarapi was also present for the meeting on the 29th of December. Indeed, Exhibit P621 demonstrates that it was Zarapi himself who convened a meeting of his directorates on 29 December. And P1408 demonstrates that Zarapi himself chaired the meeting, which was attended by B. Luja, Adam Grabovci, Fatmir Limai, Ram Buya, and Kadri Veseli. And you see that evidence on your screens now. There is no evidence that any of the four accused attended this meeting, and it has not been disputed by the SPO that Mr. Thaçi was out of the country. The SPO cites to this meeting, and in footnote 283, in support of its contention that opponents and special warfare were discussed on a recurring basis in general staff meetings. Slide 41. But how does a meeting that did not involve any of the four accused and was chaired by Bislam Zarapi, not trusted by alleged JCE members, support the SPO's contention that there was a common criminal purpose involving these four accused? The SPO is silent. The SPO suggested in its re-examination of Zarapi that there may have been two meetings on 29 December, one chaired by Zarapi that involved the meeting of his directorates, and another of the general staff. But this has not been established by the evidence, nor has the SPO established who attended such a second meeting on 29 December. Moreover, the SPO has not established that Zarapi did not attend such a meeting. The SPO never put to Zarapi that he did not attend such a second meeting. Accordingly, again, this raises the question of how the SPO could contend that the 29 December meeting was a meeting in furtherance of the common criminal purpose, given that Zarapi was likely present at the meeting and was not kept informed about the common criminal purpose according to the SPO. Slide 42. And that's it. That's all of the evidence the SPO cites to allege that opponents and special warfare were ever discussed at general staff meetings. There is no assertion by the SPO in its brief that Hashim Thaçi attended a single such meeting. Slide 43. At paragraph 110, footnote 402 of its final brief, the SPO has laid out what it claims is a list of general staff meetings. Slide 44. And in footnote 405, it has laid out a list of alleged Provisional Government of Kosovo meetings. For the record, we dispute that any of these meetings are official meetings of the Provisional Government, as opposed to meetings where some members of the Provisional Government were present. Despite all of these meetings, they are only able to allege two meetings where the issue of special war was ever discussed, and those are the two I've already addressed. Slide 45. Mr. Thaçi was out of the country for much of the indictment period, and there is no evidence that he attended most general staff meetings. Slide 46. The SPO in paragraph 113 tries to circumvent its problem of Mr. Thaçi's absence from Kosovo by arguing that the general staff members were consulted by phone or else informed afterwards of the results of general staff meetings. But the only example they cite is the case of the 8 Yugoslav army soldiers, the 8 VJ soldiers. We submit that the case of the 8 VJ soldiers is the exception rather than the rule. You can't take the specific case where Mr. Thaçi was involved on the basis of his role, in the words of Ambassador Hill and Sean Burns, as the foreign minister, and was pulled into the discussion of the 8 VJ soldiers because high-level American diplomats, such as Ambassadors Hill and Walker, and the international community were involved, and then extrapolate from that one incident that on every decision of the general staff, he was consulted by phone when he was out of the country. That requires evidence and cannot be the only reasonable inference. Moreover, the SPO implicitly acknowledges in its final brief that just because someone had a role in the release of 8 VJ soldiers does not mean that they were members of a JCE or otherwise bore criminal responsibility. The next 3 slides are not for public broadcast. Slide 48. Bislam Zarapi was directly involved in the incident concerning the release of the 8 VJ soldiers. He was extensively examined about his involvement by the SPO. That's at transcript page 17520 to 17523. He was involved in the cases of several other detained persons. The citations are shown on your screen. Yet the SPO acknowledges that he was not part of any criminal purpose, just because he was involved in discussions about their release. Slide 49. The same applies to Hashim Thaçi. Just because he was consulted about the release of 8 Serbian soldiers because it was an international incident with diplomatic ramifications does not give him any more of a criminal role in detentions than it does Bislam Zarapi. Slide 50. Furthermore, the fact that other members of the General Staff chose to ignore Thaçi's position that KLA and Serbian soldiers should be simultaneously released demonstrates that Thaçi's views were not decisive on such issues. The next slide can be publicly broadcast. Slide 51. In support of its assertion that absent General Staff members would be informed about the results of General Staff discussions after their return, the SPO uses as an example its claims in paragraphs 114 and 148 that Suleiman Salimi in February 1999 was only proposed by zone commanders to be the overall commander, and that his appointment was not approved until the return of the Rambouillet delegation. Slide 52. This claim is refuted by Exhibit 1D250, which establishes that Suleiman Salimi was publicly declaring himself as the overall commander of the KLA on the 22nd of February 1999, while the KLA delegation was still in Rambouillet. You see that evidence on your screens. Suleiman Salimi was installed by the zone commanders, not simply proposed by them. You heard that from Bislam Zarapi as well. While we are on this point, Mr. Quick said on Monday that while the final decision regarding the Rambouillet agreement was signed by other General Staff members, it was not signed by Suleiman Salimi. That was said at page 28481 to 28482. Notably, the SPO never put its case to Suleiman Salimi or anyone else that he allegedly did not consent to the Rambouillet agreement. Yet again, the SPO was too afraid of the answer. Slide 53. But as you see from the excerpt of Suleiman Salimi's interview on this screen, which the SPO admitted into evidence, Salimi confirmed that Thaçi consulted him and Salimi gave him his consent thereafter. This is the only admitted evidence that directly addresses the issue. Slide 54. And this next slide shows a photo from the meeting in March 1999 when Salimi gave his consent to Thaçi. Once again, this is the SPO's own exhibit. Slide 55. As a final note here, yesterday, while discussing the February meeting that took place between the zone commanders and several members of the General Staff, Mr. Halling stated that the defense was attempting to brand the meeting as a coup by the zone commanders. That was at transcript page 28519. The SPO never challenged Remy's acknowledgement of the coup, nor Zarapi's acknowledgement of the coup, nor Sean Burns, who was on the ground in Kosovo, had extensive contacts with the KLA, and was cross-examined extensively on the coup, and confirmed that he was aware of the coup. In fact, it was not the defense who called it a coup, but Burns who called it a, quote, palace coup in a code cable which the prosecution admitted as Exhibit P1080. To say that there was no coup or that there wasn't a reasonable inference that there was a coup is yet another unserious argument by the SPO. I would like to spend a few more minutes going over the testimony of Bislam Zarapi and how else his evidence affects the SPO's JCE case. The SPO's admission that Zarapi is a credible witness and that it does not allege he was part of any joint criminal enterprise is a crucial blow to the house of cards that is the SPO's case. Slide 56. He was the chief of the general staff. You see his testimony on your screen where he acknowledged his role as chief of the general staff and his acknowledgement that the directorates were subordinated to him. He was at the center of everything in the general staff. If there was a JCE in the general staff, there is simply no way he would not have known about it. And his order in 1D29 establishes a reasonable inference that he was not in any JCE and that there was no JCE. The next two slides are not for public broadcast. Slide 57. Zarapi's evidence is that there was no JCE in the general staff, and he has been saying this since at least 2005, where he told the ICTY that prior to late November 1998, the general staff had issued no orders on the issue of detentions, and that detentions were a matter that had been handled by the zone commanders. He told the ICTY that he had heard complaints about such detentions when he visited the local commanders in the zones, and that he issued an order in late November 98, which you know as 1D29, in order to be able to take disciplinary measures and for soldiers to know what the right procedures were. You see his 2005 evidence on your screen. Slide 58. Zarapi also told the ICTY in 2005 that, quote, until late 1998, it is an obvious fact that more power laid in the hands of zone commanders than in the hands of the general staff. The next slide may be broadcast to the public. Slide 59. Before you, he agreed that the February 1999 coup by the zone commanders actually demonstrates that the zone commanders continued to have real power well into 1999 and not just until late 1998. Slide 60. Zarapi has been saying for more than 20 years that there were no general staff orders concerning detentions prior to his order in late November 1998. Zarapi has been saying for more than 20 years it was the zone commanders who had been detaining people, not the general staff. The SPO cannot dismiss his evidence as that of someone who is now changing his evidence due to a climate of fear in Kosovo or because of a relationship with Mr. Thaçi. He has been consistent on his evidence over a very long period of time, which the SPO admits in paragraph 1433 of its brief, wherein it says that Zarapi, quote, has given largely consistent evidence over time before different courts and stood behind those statements. Slide 61. How could Zarapi, who was the one issuing many of the orders, not know if such a policy existed? At paragraph 74 of the SPO's final brief, you see there on your screens that the SPO says that Zarapi on 28 November 98 issued an order which, quote, increased centralized control over arrests and detentions by directing that they could only be ordered by brigade commanders and higher superiors except in critical military situations or when there were, quote, criminal acts against members of the KLA, individuals, or civilian authorities. So the SPO is telling you that it was Zarapi who was increasing centralized control over arrests and detentions, but that he was someone whom the JCE members did not trust to include in the criminal overall policy and is not even alleged to have been a JCE member. Slide 62. So how does the SPO reconcile the chief of the general staff being outside the criminal purpose, but exercising centralized control over detentions and arrests? Well, in footnote 280, they cite Zarapi's evidence that the order was issued as an attempt to address complaints about conduct of KLA soldiers, and that the General Staff, quote, wanted to show the internationals that we were a disciplined army. And you see both the SPO's footnote and Zarapi's testimony here. This is exactly what we say. The General Staff knew it needed the international community. It wanted to be seen as complying with international law and standards. Zarapi issued such orders precisely for that purpose, among others. This clearly establishes a reasonable interpretation of the evidence that the General Staff was attempting to stop mistreatment of persons and not instigate it. Slide 63. If the accused were involved in a common criminal purpose to commit war crimes and crimes against humanity in order to seize power in Kosovo, Bislam Zarapi would have had to have known about it. And he denies any such purpose existed. The SPO has told you he is a credible witness. How could any reasonable trier of fact come to any other conclusion but that Zarapi's evidence alone establishes reasonable doubt about the prosecution's case? And when Zarapi's evidence is considered in the context of the parade of international witnesses who told you essentially that they agree with Zarapi, what else needs to be said? Slide 64. How was the common criminal purpose allegedly disseminated to the lower levels? The SPO has laid out its allegations in its table of contents right there. That's how they allege it was disseminated to lower levels. Through dissemination in public statements, dissemination in regulatory and training documents, and dissemination in meetings and reports. And I will allege each of these in turn. But you should note here on the SPO's own table of contents, in a section identifying its arguments about how the common criminal purpose was transmitted to lower levels, that there is a concession by the SPO that it has no case that any criminal plan was transmitted through any written orders. The first alleged means is public statements. Slide 65. And the first means of public statements is communiques. But there is yet another fundamental contradiction in the SPO's case. On the one hand, the SPO says that the KLA had a fully functioning command system from the General Staff down to the zones. That's at paragraphs 105 to 109 of their brief. The ability to communicate between the General Staff and the zones. That's at paragraphs 210, 218, and 219. The ability to issue binding orders from the General Staff to the zones. That's paragraph 128. And the ability to instill discipline and punish lower levels for noncompliance. That's at paragraphs 141 and 285. Next slide. But the SPO says that despite this fully operational system of command and control, a, quote, core means, close quote, by which JCE members communicated the alleged opponent policy was through communiques, political declarations, and other public statements of the JCE members, which the KLA soldiers had to obtain through public media. That's paragraph 67 of their final brief. Slide 67. Slide 67. The SPO does not explain why the JCE members did not simply issue orders targeting the so-called opponents. We submit it is because the SPO case is internally inconsistent. And in fact, there was neither command nor control, nor any credible evidence that the zones interpreted communiques as establishing a policy to commit crimes against people perceived to be obstructing the JCE members' alleged desire to take control of Kosovo. Slide 68. In paragraph 225 of its final brief, the SPO also says, under Thaçi's leadership, the political and information directorates were key in the formulation and dissemination of internal and external policy, including in relation to the identification and treatment of opponents. Through the issuance of statements, political declarations, and communiques, the information directorate disseminated the information and propaganda which the political directorate shaped. I will address the SPO's claims concerning Mr. Thaçi's alleged leadership of the political and information directorates a bit later. But for now, let me highlight yet another contradiction in the SPO's case. Slide 69. On the one hand, their case is you should discount the evidence provided to you by multiple high-level international officials, some called by the SPO, such as Sean Burns, and others called by the defense, such as James Rubin, Christopher Hill, General Wesley Clark, James Jock Covey, John Duncan, Paul Williams, and Michael Durkee, because all of these internationals did not have information available to them that you have available to you. But their case against Mr. Thaçi hinges in part on statements, declarations, and communiques that were by definition in the public domain and readily available to the international media, diplomatic, and intelligence communities. The internationals were well aware at the time of all of these, and they did not see an incitement to crime or a common criminal purpose. Slide 70. And what about Mr. Zarapi, the insider, the chief of the general staff, who was not aware of the common criminal purpose and from whom the other JCE members concealed the common criminal purpose according to the SPO? If the communiques and public statements were the means through which a criminal policy was transmitted, how does the SPO explain why Zarapi didn't get the message? Did he not read communiques and political declarations? Why would the SPO say that other members had to make efforts to conceal the common criminal purpose from Zarapi, while at the same time those same JCE members were broadcasting the common criminal purpose in the media? None of this, Your Honors, makes any sense, let alone constitutes proof beyond reasonable doubt. How is it that the SPO can argue that both the internationals and the chief of the general staff didn't know about the common criminal purpose, but the lower level KLA personnel were able to receive the criminal message? Slide 71. Ask yourselves this question. Did it take 20 years for the international community to discover the insightful propaganda of the genocidaires in Rwanda? Did it take 20 years for the international community to discover the nationalist propaganda of the Bosnian Serbs and the Milosevic regime? Of course not. The inflammatory rhetoric in Rwanda and Serbia and Bosnia was self-evident and immediately reported. And had the KLA's communications been inciting crimes in Kosovo, the international witnesses from whom you heard would have known about it. The SPO's case is that by the time Mr. Thaçi was in Rambouillet, a persecutory KLA campaign of war crimes and crimes against humanity had been unfolding for 11 months. Yet Professor Paul Williams told you that no one in the contact group ever mentioned to Thaçi that he needed to do something. Instead, Williams told you it was Thaçi and the Albanian delegation pushing for the ICTY to be allowed to investigate war crimes by all sides, including the KLA. Slide 72. The next point. The SPO has failed to prove that communiques furthered a JCE policy. What is the evidence the SPO cites to establish any causal link between communiques and any charged crimes committed in the zones? Slide 73. The SPO must prove that communiques were a significant contribution to the commission of the charged crimes, not simply to the common purpose, as the SPO claims throughout its brief. And therefore, the temporal link between the communiques and charged crimes must be sufficiently significant. Slide 74. The SPO first relies on the evidence of Commander Remy to support the allegation that the communiques amounted to a significant contribution to the charged crimes. First, it should be noted that the SPO case is that Remy was communicating directly with the general staff. You see there at paragraphs 354, 356, and 362 where the SPO makes these allegations. Indeed, the SPO expressly states at paragraph 362 that, quote, Mustafa and the Lap Zone Command maintained close contact with and reported to the General Staff, both in person and via satellite phone. Slide 75. This raises the obvious question. Then why didn't the JCE members communicate the criminal plan to Remy in person or through satellite phone or otherwise through its, quote, close contacts? Why would Remy need to read about policy in Communiqués? Why wouldn't he be receiving direct orders from the General Staff or be asking the General Staff if he should set up detention centers? The reason that the SPO has to say that the General Staff communicated the common criminal purpose through Communiqués to the zones, including the Lap Zone, despite, quote, close contact in person and via satellite phones, close quote, is because the SPO has no evidence of any direct orders or communications from the General Staff conveying the alleged common criminal purpose. One reasonable inference on the evidence on the SPO's own case is that if the General Staff members had a criminal plan that they wanted Remy to implement, they would have communicated that plan to him directly, and there is no credible evidence that they did. Slide 76. The SPO notes that Remy claimed that, quote, communiques were part of my military rationale. Slide 77. But Remy was speaking about Communiqué 54. Remy confirmed this at trial at pages 5848 to 5849 and at 5861. Communiqué 54 was issued in late September 1998. The prosecution's case, as charged in the indictment, is that detentions in Remy's zone began on or around the 2nd of August and lasted until mid-September. The communiqué Remy mentioned seeing after the September offensive was published after his zone had been detaining people for 7 weeks. The communiqué could not have amounted to a significant contribution to the detentions because they post-date them. In fact, the last of the detainees in Remy's zone were released shortly after the publication of Communiqué 54. That's at transcript page 5726 to 5727. Slide 78. And Remy acknowledged that he had set up detention sites well before he allegedly saw the communiqué. That's at transcript page 5849. Slide 79. The SPO misquotes Remy at paragraph 67 of its final brief, where it cites to Remy's testimony in support of the claim that, quote, communiques were understood by KLA commanders as communicating KLA policy and authorizing measures against opponents. Remy did not say that. As you see on your screen, Remy said that he was made aware during his own trial of a document that was circulating that said that those who were working against the KLA should be prevented from doing so, but that he did not recall seeing something specific from the General Staff in relation to the matter while he was zone commander. That's at transcript page 5558. Slide 80. Next, the SPO claims that the common criminal purpose was furthered because KLA officials failed to properly define the term collaborator for subordinate units. But the fact that KLA officials in propaganda statements and political rhetoric may have used the term collaborator in a colloquial manner rather than using a legal definition is irrelevant unless the SPO can prove that the General Staff members were intending to address subordinate units, either in the form of orders or through communiques. We know that the SPO has effectively conceded that there are no internal KLA orders from the General Staff where the issue of collaborators is addressed. And as I've just mentioned, there is no credible evidence that the General Staff intended to communicate to the zones through communiques. Accordingly, the colloquial use of the term collaborator in propaganda statements is not evidence of a significant contribution to the commission of crimes. I'll turn next to the issue of regulatory and training documents. Slide 81. The SPO further claims in paragraph 71 that regulatory documents, such as the Provisional Rules of Organizing Internal Army Life, were adopted by the General Staff in July 1998 and embedded the requirement that the KLA military police be, quote, merciless toward the enemy and all those who obstruct the liberation war. The SPO's only cite in support of the allegation that these rules, which were admitted as P8, were approved at a General Staff meeting on 4 July 98, is Jakub Krasnici's book. However, there are no minutes of a General Staff meeting approving such rules on 4 July 98 in the record, and the SPO does not establish that P8 is indeed the regulation that was allegedly approved at this meeting of 4 July 1998. Furthermore, there is no evidence that Mr. Thaçi ever attended any such meeting or that he was even in Kosovo in early July. On the other hand, Zarapi, a witness whom the SPO deemed credible, when shown the provisional rules known as Exhibit P8, stated that the rules were drafted at the end of 1998 as part of the restructuring and were translated from documents from Western armies. Zarapi explained that these rules were mainly aspirational and were not implemented on the ground. Slide 82. Indeed, P8 contains regulations which contain an oath that swears allegiance to Chiliku. There is reasonable doubt as to whether the General Staff would have approved regulations for distribution across Kosovo that contain an oath to Chiliku alone. Slide 83. The SPO also claims that shortly after a General Staff visit to the LOP zone, the KLA Public Information Service, led at the General Staff level by Thaçi, issued a booklet on special warfare. And that's at SPO's final brief at paragraph 72. First, there was no KLA Public Information Service, and the SPO cites to no evidence of what this alleged entity was or how Thaçi led it. Second, the SPO misrepresents the evidence. The booklet bears the title of the LOP Zone Information Service on the last page. It was never issued by a public information service at the General Staff level. In addition, as explained in our final brief at paragraphs 157 and 300 to 304, the evidence does not support the SPO's claim that special warfare was discussed during the General Staff visit to LOP in October 1998. The SPO does not show, much less prove, that the October 1998 General Staff visit to LOP led to the issuance of this booklet. Contrary to the SPO's claims in footnote 276, when shown the booklet, Rustam Mustafa did not recall it, so he couldn't have confirmed the authenticity of it. That's at transcript page 5651 to 5652. Turning to the third means of transmission of the common criminal purpose, meetings and reports. On Monday, Mr. Tiger said, quote, Sokol Bashota noted in his ICTY interview that collective decision-making applied to decisions about collaborators. That's at transcript 28371. Slide 84. However, there was no reference to Bashota's testimony before this court. Bashota discussed a series of meetings of the General Staff during his testimony and noted that while meetings of the General Staff were held and were taken based on a majority of the people present at any meeting, and they had a horizontal structure in the sense that they were not giving orders to each other, he also noted that not all members of the General Staff participated in every decision. Decisions could be taken in the absence of people, and each member had their own duties and responsibilities. Importantly, Bashota agreed with the explicit propositions that the following were not collegial decisions: issuance of communiques, treatment of collaborators, issuance of regulations, creation of detention centers, media interviews given by KLA members, the Holbrooke-Milosevic Agreement, the FARC Agreement, who should attend the Rambouillet Conference, the appointment of Adam Demachi, and the role of Sokol de Bruna. Upon being shown various orders signed by Zarapi, Bashota confirmed that all such decisions had been issued on his own without consulting the general staff, i.e., not collective decisions. Bashota ultimately agreed with the proposition that there were major decisions being taken on behalf of the KLA that did not involve a collective or collegial decision-making process. Slide 85. The SPO next says that the common criminal purpose was conveyed on general staff visits to Shala and Lap in August 1998 and to Dukajin in September 1998. We have addressed these claims in paragraphs 146 to 155 of our final brief, and I've already mentioned that Bislam Zarapi was present and participated in every one of these visits, and on the SPO's case was not a participant in discussions about the common criminal purpose. There is therefore a reasonable inference that these meetings did not transmit any criminal purpose to the zones. I want to raise an issue here about military objectives. The SPO claims that the fact that multiple KLA zones set up detention facilities means that the only reasonable inference you can draw is that they were set up by the general staff. But this is not true. This argument fails to take into account two fundamental points. Slide 86. First, the ICRC has explained that detention by states and non-state armed groups, such as the KLA, is a reality in every conflict. It is an expected part of warfare. It is the norm, not the exception. The ICRC states that IHL is built on the assumption that all sides will detain. It would have been unusual if the zone commanders did not set up their own detention facilities. They did not need to get the idea to do so from the general staff. Slide 87. And these are the ICRC guidelines, where it says that it may take time for non-state actors to set up systems of due process. The reason that all sides in armed conflict detain is because it is a military byproduct of war. You will capture the other side's combatants, you will need to discipline your own forces and detain them, and you will need to detain those directly participating in hostilities. The SPO here has stated that it does not dispute that the KLA had a right to lawfully detain. Slide 88. The SPO therefore has to demonstrate that even if it could prove that there were communications between the general staff and the zones about special warfare and collaborators, those discussions were not in pursuit of legitimate military objectives, but rather were in pursuit of a political objective of the JCE members seizing power in Kosovo. Remember, if you were to conclude that abuses occurred as a result of a KLA policy to advance its military objectives, or as a result of personal grievances on the part of the KLA individual members, then you must reject the JCE mode of liability because that is not what has been charged. Their case is that all of the alleged victims were detained and abused because they were an impediment to the JCE members' political objective of gaining and exercising control over all of Kosovo. That is not the only reasonable inference you can draw on the evidence, and you therefore must reject the JCE charges in this case. This leads to our next point. The SPO has failed to prove that there was an intent to seize control of Kosovo. Slide 89. There is no evidence that the LPK had a goal to seize control of Kosovo for itself. The LPK statute here, which you see on your screen, made clear that its objective was, first, the liberation and creation of an independent state of Kosovo, and second, to create a new, free, and democratic society in line with the will of the people. There is no suggestion in the LPK statute that the LPK's objective was to seize power for itself or its members. Slide 90. In support of its claim that the JCE members had a goal to seize power for themselves, the SPO cites the Political Declaration number 8 at paragraph 10 of its brief, where the SPO takes a sentence out of context that says, Kosovo will be ours or it will be turned to ashes. But the rest of the text goes on to make clear that Kosovo will be ours refers to the people of Kosovo generally and not to the alleged JCE members. The statement says, Kosovo will be ours or it will be turned to ashes. We are convinced that death is nobler than life under slavery. Life under slavery here clearly refers to the people of Kosovo and not to the alleged JCE members. And then Political Declaration number 8 concludes by saying, our war is for freedom and for better future and real democracy. Real democracy would be incompatible with a unilateral seizure of power by the alleged JCE members. And again, it is unclear how the SPO reconciles its claim that the international witnesses and Bislam Zarapi were all uninformed about the criminal plan of the JCE members, but then relies on a public political declaration as evidence of criminal intent. The fact that the international witnesses and Zarapi did not read this declaration in the same way that the SPO spins it is itself reasonable doubt about the SPO's interpretation. Slide 91. In paragraph 27, the SPO claims that the deployment of, quote, relatively senior LPK volunteers in March 1998, quote, increased the authority of Thaçi and other LPK-affiliated KLA general staff members. The SPO does not cite any evidence to establish that these were, quote, relatively senior, close quote, people in the LPK, or how the SPO arrived at a definition of that term. In addition, we are once again faced with another contradiction in the SPO's case. How does the SPO reconcile its claim that Thaçi derived his authority from other LPK-affiliated general staff members on the one hand, with its position on the other that it was Thaçi who brought in and deployed Zarapi and other military officers to professionalize the KLA? Zarapi came into Kosovo with Thaçi, and there is zero evidence that he had anything but a good relationship with Thaçi. He never suggested otherwise in his testimony. Slide 92. In paragraphs 188 and 190 of the SPO brief, the SPO itself says that the, quote, accused's role and authority over operational matters is illustrated by their installation, appointment, and oversight of Zarapi, an experienced military officer who had operational roles in the General Staff and Ministry of Defense during the indictment period. That's paragraph 188. They go on to say in paragraph 190 that, quote, Thaçi also gave Zarapi the order to prepare professional officers and post them to the war zones. Slide 93. How does the SPO explain its position that it was Mr. Thaçi and the other accused who installed an experienced military officer, someone who was former JNA and was not part of the LPK, to run the operations of the KLA and ultimately to become the chief of staff, chief of the general staff, while also arguing that the accused excluded him from the alleged common criminal purpose in pursuit of LPK goals? You would be more than reasonable to conclude that a reasonable inference is that the accused supported Bislam Zarapi's ascent to a leadership position in the general staff because there was no common criminal purpose, and to conclude that there is a reasonable inference that Hashim Thaçi would not have encouraged the deployment of professional officers not affiliated with the LPK if he were in fact attempting to make a significant contribution to the alleged common criminal purpose. Also, Zarapi made clear in his testimony at pages 17784 to 17786 that every Albanian former military officer who made himself available to the KLA was accepted into the KLA. There is no evidence that any former military officers were excluded. Accordingly, this claim that the accused were placing ideologically LPK-aligned people in places of authority as a litmus test is contradicted by Zarapi's evidence. Moreover, the SPO in paragraph 405 says that, quote, throughout early 1999, the General Staff exhibited increasing distrust of former professional soldiers and those viewed as LDK or FARC affiliated. But the General Staff was led by Zarapi, himself a professional soldier. How does the SPO place collective blame on the, quote, General Staff, close quote, exhibiting distrust when Zarapi was in charge of the General Staff? Also, the SPO says it was Thaçi who, quote, gave Zarapi the order to prepare professional officers and post them to the war zones. On what evidentiary basis does the SPO suggest that Thaçi became distrustful of professional officers that he himself allegedly deployed and posted, especially at a time in early 1999 when Thaçi himself was not even in the country? Slide 95. I think I can do this. The SPO claims, the SPO next relies on certain public statements as evidence of an intent to seize power in Kosovo. The SPO claims in paragraph 13 of the SPO brief that by the start of the indictment period, the KLA leadership was making clear demands to be recognized as the, quote, only legitimate authority representing the Albanian people. Slide 96. It relies on Communiqué 44, which purports to have been sent from Pristina on 2 March 1998 by the, quote, Central Staff. But the SPO has not established who in the KLA leadership allegedly prepared this statement. There is no evidence of any connection to Hashim Thaçi. Mr. Thaçi was not in Kosovo at the time this was purportedly sent. Slide 97. At paragraph 16, the SPO says all political parties were to cease their independent activity and pledge absolute allegiance to the KLA. The SPO cites the political declaration number 3 of 10 June 1998, which if you read it, you will see that the SPO has grossly misrepresented the document. Nothing in here supports the SPO assertion. Again, the SPO did not put these public statements to any witness to see if anyone interpreted this as claiming that the KLA was demanding a pledge of absolute allegiance to the KLA. Mr. President, this is convenient for a break.
We'll take our half-hour morning break now. Please be back in your seats at 11 o'clock. We're adjourned until 11.
All rise. All rise.
Be seated. When you're ready, you may proceed, Mr. Misitich.
Thank you, Mr. President. And just for the benefit of the interpreters, I am behind, so I'm going to be skipping portions of my prepared remarks, and I will identify the slide that I'm going to start speaking about next. So, thank you. And we will start at slide 101. The SPO next contends that the intent to seize power across all of Kosovo is evidenced by the work of certain directorates of the General Staff, beginning in November of 1998, including the Civil Administration Directorate, the Information Directorate, the Personnel Directorate, and the Military Police Directorate. but these directorates reported to Zarapi. Again, this is the organogram of the general staff, which the SPO created and showed you on Monday. You see there that on the SPO's case, all of these directorates reported to Zarapi. Now, taking a look at the Civil Administration Directorate, slide 102. The SPO relies heavily on its allegation that the Directorate for Civil Administration, headed by Ram Buya, was a tool through which the objective to gain and exercise control over all of Kosovo was implemented. As you saw on the organogram, Ram Buya was subordinated to Zarapi in November of '98, including the Civil Administration Directorate. The SPO does not allege that the Directorate was subordinated to Hashim Thaçi. How could the Public Relations and Civil Administration Directorate have been implementing the common criminal purpose while subordinated to Zarapi, who was not involved in the JCE according to the SPO? Slide 103. Just as importantly, why didn't the SPO ask Zarapi a single question about the work of the Civil Administration Directorate? Why it was formed, what its tasks were, and whether he has reason to believe it was operating as a vehicle for the accused, in this case, to seize power in Kosovo. The SPO never put its case to Zarapi for obvious reasons. Zarapi would have rejected the SPO's claim that the Civil Administration Directorate was used to implement the alleged common criminal purpose. Slide 104. We know this because we have Zarapi's ICTY testimony in evidence, P1356, wherein on page 5942, Zarapi told the ICTY that a Directorate of Civil Administration is part of the, quote, ordinary structure, close quote, of a general staff that would exist anywhere. Had the SPO put its case to Zarapi on this issue, the trial panel would have seen Zarapi's reaction to the SPO's claim, raised on Monday, that, quote, Thaçi used the PGOK as a cloak for plans that had already been put in place through the Civil Directorate. Given Zarapi's ICTY testimony, you may reasonably infer that Zarapi would have denied that the Civil Administration Directorate, under his direct command, was being used for such a purpose. Slide 105. Accordingly, one reasonable interpretation of the evidence is that a Directorate for Civil Administration was established because the trained military officers of the KLA, such as Bislam Zarapi, believed this was a normal part of establishing a general staff, and not because of some common criminal purpose made by the accused behind Zarapi's back. We will skip ahead to slide 111, please. For the interpreters, that's page 53 of my remarks. Next, the SPO claims that the PGOK was a structure through which a plan to seize control of Kosovo was implemented. As you know, the provisional government was not created as part of a plan to seize control of Kosovo, but rather as part of an agreement at Rambouillet with President Rugova of the LDK and Professor Chosia of the LBD. It was, in effect, intended to be a government of national unity, with President Rugova remaining president and the KLA appointing the prime minister of the government and the LDK and LBD each receiving a deputy prime minister post. The three parties were to split ministerial posts equally. At the outset, let us correct a few misrepresentations made by the SPO in this section of their brief. In paragraph 143, they write, quote, around the same time, meaning the summer of '98, the General Staff, having consistently and vehemently rejected the elected LDK government, initiated steps geared towards the creation of a new government. First, it is important to note that this is factually and legally incorrect. There was no, quote, elected LDK government. There was no election, and there was no LDK government. The LDK was a political party and itself a non-state group, and the so-called elections it held were non-state elections. The Bukoshi government was not even in Kosovo, but was an exile so-called government. The LDK had no more of a legal claim to authority than did the KLA or any other group. Second, in support of the assertion that the KLA, quote, initiated steps geared toward the creation of a new government, the SPO cites to Political Declaration Number 7. But it is clear that Political Declaration Number 7 is addressing the issue of the creation of new institutions within the scope of the negotiations to be held with Serbia and mediated by Ambassador Hill. The declaration did not assert that the KLA was creating a new government of its own to the exclusion of the LDK. Slide 112. Next, at paragraph 160, the SPO write, PGOK appointments included limited LBD members in ministerial posts and assigned one deputy post to the LDK, with that post remaining vacant. First, the post assigned to the LDK in the provisional government was the deputy prime minister post. Second, when the SPO writes there were limited LBD members in ministerial posts, they failed to disclose that 5 ministerial posts were assigned to the LBD. In its announcement of the formation of the PGOK, which is Exhibit 1D70, the PGOK made clear why even more LDK posts had not been filled as envisaged in the Rambouillet Agreement. Quote, even though the deadline was postponed several times, the LDK still did not send its proposals as foreseen in the agreement. Accordingly, if the LDK did not have the same number of ministerial posts in the PGOK as did the KLA and LBD, that is because the LDK chose not to nominate anyone to fill its quota of posts. The fact that the LDK did not participate in the PGOK was based exclusively on the decision of the LDK to boycott the PGOK because they no longer wanted equal power sharing in the PGOK, but rather wanted to have more representation than the KLA and LBD, even though that was contrary to the agreement reached at Rambouillet. We explain all of this in paragraph 64 of the Thaçi final brief. The SPO, in its final brief, now argues, for the first time in this trial, that the LDK had good reason to boycott the PGOK, allegedly because of KLA threats. All of this is SPO spin, because no witness or document says that this was the reason they boycotted. And this last-minute SPO theory was something they never put to any prosecution or defense witness. The fact is, Secretary of State Albright and Prime Minister Blair were calling on the LDK to participate in the PGOK, and they continued to refuse. There is no evidence that the LDK told anyone at the time, including the United States and United Kingdom, that they refused to join because of alleged KLA threats. Slide 113. But the key point here is that Mr. Thaçi was being meaningfully inclusive of the LDK throughout the spring and summer of 1999. Thaçi repeatedly and consistently called on the LDK to honor the agreement reached at Rambouillet and to join the PGOK, including by taking up the post of Deputy Prime Minister. You can read that at paragraph 25 of the Thaçi final brief. Furthermore, Mr. Thaçi publicly confirmed that the objective of the PGOK was not to, quote, gain and exercise control over Kosovo for the alleged JCE members, but for the PGOK to govern only until the first free democratic elections could be held. And that's an interview of Mr. Thaçi's, which is in evidence at P813.24. And you see that on your screens. Indeed, it is widely accepted that during and after Rambouillet, Mr. Thaçi was someone who wanted to remain in the good graces of Secretary Albright, specifically, and the United States generally. The idea that he would want to do anything other than have the PGOK act as a transitional government until free and democratic elections could be scheduled would be wildly inconsistent with his ambition to remain close to the United States, and is indeed refuted by the fact that he actually did participate in Kosovo's subsequent democratic elections, and he conceded when he lost elections. Slide 114. Let's look at what evidence the SPO cites to support its claim that Hashim Thaçi was a member of the alleged JCE. And let's first, in that context, look at the question of whether the SPO has proven that Hashim Thaçi made a significant contribution to the alleged JCE. The first way the SPO alleges that Hashim Thaçi significantly contributed to the JCE was by allegedly formulating and implementing plans, policies, rules, structures, and reporting. The SPO argues that Thaçi was a leading figure of the LPK, KLA, and PGOK, and as such, Thaçi was directly involved in the formulation, approval, dissemination, implementation of plans, policies, and practices in furtherance of the common purpose. Let's break this allegation down. Slide 115. The issue of whether Thaçi was a leading figure. The SPO has failed to establish beyond reasonable doubt that Thaçi was the, quote, leader of either a political directorate or information directorate prior to November of 1998, when he became the head of the political directorate only. While there is evidence that Mr. Thaçi was involved in public relations and media prior to November 98, the SPO cites no credible evidence that he was the, quote, leader or head of any directorate of the KLA, whether political or information, and no evidence that Mr. Thaçi controlled or supervised what others in the KLA were saying or publishing in the media. On Monday, you once again heard the claim that Mr. Thaçi was head of the Information Directorate until November 98. Once again, no evidence was cited.
The speaker is kindly asked to slow down while reading so that we could complete our interpretation. Thank you.
I'm surprised it took this long. But, yeah. Slide 116. Thaçi did not control KLA public communications. The SPO alleges at paragraph 68 of its brief that the General Staff Information Directorate, including Thaçi personally, had significant control over public communications, including, for example, making decisions on what to inform the public of, exercising control over interviews given by KLA commanders, and staging supportive public statements. But you heard evidence from witness Maloku that even when Thaçi urged him not to speak to the media, he continued to do so anyway. Maloku's evidence alone establishes a reasonable inference that Thaçi could not control what KLA soldiers in the field would or would not say. And you see his testimony on this slide. The SPO next contends that Thaçi's political directorate played a central role in KLA operations and in the treatment of opponents. Slide 117. Let me start here by briefly addressing an argument raised by Mr. Halling, claiming that Sokol Bashota's testimony that Mr. Thaçi was not a founder of the Central Staff is, quote, uncorroborated. This is not true. The SPO apparently simply ignored our brief, in which we cited the 2002 interview of Naid Hassani, wherein he confirmed the exact same founders of the Central Staff as Sokol Bashota. Mr. Thaçi was not among them. See 1D223. Nor did Mr. Thaçi claim to the SPO that he was a founder of the Central Staff or General Staff, as opposed to one of the founders of the KLA as a movement. There is, at the very least, reasonable doubt about this issue. At paragraph 224, the SPO claims that Hashim Thaçi headed the political directorate by at least June 1998. Slide 118, please. But Bislam Zarapi told you that Hashim Thaçi dealt with media and public relations and foreign affairs prior to November 98, not the political directorate. There is no evidence of any functioning political directorate before then. Recall the evidence of Ambassador Hill, that he spent the entire summer looking for a KLA interlocutor and couldn't find one, culminating with him telling a Washington, D.C. audience in September 1998 that if you want to bring the KLA to the negotiating table, you'd better have a big table. That's transcript page 27677. The SPO, once again, never challenged him by showing him evidence of a functioning political directorate in control of KLA policy at the time, headed by Hashim Thaçi. As for the SPO's reliance on Nuhi Batucci's book, claiming that Thaçi was claiming to be the head of the political directorate in late October 1998, see Monday's transcript at 28473, this is yet another claim that the SPO never put to the witness. We encourage you instead to review the video of Thaçi's first public appearance, recorded in late October, but broadcast in late November, where Thaçi is not identified as having any such title. See P1256. The witness himself, on cross-examination, testified in court that Mr. Thaçi was not the head of the political directorate until November 1998. That's at transcript page 16783. The SPO did not challenge his evidence in redirect by referencing his book. Slide 119. Zarapi then told you that beginning in November 98, Thaçi led the political directorate and was not involved in military matters. And you see his evidence there on this slide. We know that Bislam Zarapi led KLA operations since at least July 1998, first as head of the operations directorate and then as the chief of the general staff. Zarapi told you that Thaçi did not have a role in KLA military operations, let alone that he played a central role in such operations. The SPO has told you that Zarapi is a credible witness. The SPO did not challenge Zarapi's evidence on this point over 3 weeks of his testimony. You should not give any weight to any SPO claim that Zarapi was not being candid out of loyalty to Mr. Thaçi or fear of a supposed climate of intimidation in Kosovo, where the SPO was too afraid to put its case to him to give him a fair opportunity to comment. It is not fair to the witness, and it is not fair to the accused. You should credit Zarapi's evidence as establishing reasonable doubt about the SPO's claims. Next, the SPO cites no evidence in support of its claim that Thaçi was a leading figure in the LPK. No citation for that is provided at all, and the claim is disputed as unsubstantiated. Slide 120. The SPO claims that Thaçi oversaw the dissemination of public information, ensuring that it espoused the KLA General Staff's strategy as it developed. There is no credible information that Hashim Thaçi oversaw the dissemination of public information. In particular, the SPO has failed to establish, beyond reasonable doubt, that Hashim Thaçi had any involvement at all in the preparation of communiques and political declarations. No witness testified to that effect. None of the numerous books, manuscripts, notes, newspaper articles, and the like in the record contain even hearsay recollection by someone that Hashim Thaçi authored communiques and political declarations. In fact, in paragraph 1477, footnote 6234, the SPO is only able to cite 2 pieces of evidence in support of their claim that Hashim Thaçi had a role in the preparation of communiques. Slide 121. The first is Recep Salimi's SPO interview, wherein he claimed that Hashim Thaçi had some connection to Communiqué 59. Salimi's claims cannot be believed for numerous reasons, all of which we have outlined in paragraphs 236 to 241 of the Thaçi final brief. In his SPO interview, Salimi told the SPO that he has no knowledge, no personal knowledge, of who drafted any of the KLA communiques and could only make assumptions. Moreover, his claims about Communiqué 59 are uncorroborated, and Mr. Thaçi did not have any opportunity to challenge Mr. Salimi's testimony under cross-examination. Pursuant to Rule 140, the trial panel should therefore not use his evidence against Mr. Thaçi. Finally, we note that Mr. Salimi himself, in his final brief at paragraph 614, has acknowledged that he has no knowledge of who drafted communiques and that he was only speculating in his SPO interview. Slide 122. The second and last piece of evidence relied on by the SPO to prove that Mr. Thaçi allegedly had a role in the drafting and dissemination of communiques is an excerpt from a book written by Nuhi Batucci, in which Batucci writes that in late October 1998, Mr. Thaçi had asked Batucci to write a bulletin to international media and report that Thaçi had met with Burns, from which the SPO cites to an information note that was published by the Information Directorate on 1 November, reporting on the KLA's meeting with Sean Burns. And that is Exhibit P303, the last page. You see that information note now on this slide. The document is entitled Information Note, not Communique or Political Declaration. It is very factual. It is a very factual report to media about the substance of the KLA's meeting with an international official. There is nothing related to so-called opponents or special warfare in the information note. And this document in no way supports the SPO's contention that Mr. Thaçi was involved in drafting communiques generally or ones that discussed collaborators or special warfare specifically. That's it. The SPO cites no other evidence that Mr. Thaçi had any role in the drafting and dissemination of communiques and political declarations. Moreover, even if the SPO could show a connection between Mr. Thaçi and communiques and political declarations, the SPO has failed to show that these communiques and political declarations were a significant contribution to any of the crimes charged in this case. And I will address the legal issue there later in my submissions. Yesterday, Mr. Halling appeared to suggest that Mr. Thaçi was somehow connected to a purported military police communique concerning Messrs. Descu and Castrati. That allegation is not made in their brief. The only specific communiques to which the SPO connects Mr. Thaçi are the ones identified in the footnote I have just discussed. Slide 123. Next, the SPO alleges that Thaçi framed opponents as threats and warned that they would face punitive measures. That's paragraph 484. But footnote 211, which supposedly supports that, is a reference to a section on Mr. Krasniqi. It is unclear to us how this section supports the claim that Mr. Thaçi threatened opponents, and we therefore have no material ability to respond to the claim and reserve all rights. Slide 124. Thaçi participated in strategic general staff visits to operational zones to formalize command, instruct commanders on special warfare, and align them with the targeting policy, ensuring field-level execution of the common plan. So says the SPO. This is quite a bombastic claim that requires you to once again dig into the footnotes to assess what this is about. And this is about the trips of the general staff, including Hashim Thaçi and Bislam Zarapi, to Shala, Lap, and Dukajin zones. which I have already discussed. The SPO has failed to meet its burden of proving that there was discussion of special warfare in these meetings with the zones for the purported purpose of, quote, aligning them with the targeting policy. Once again, it is unclear how the SPO can both admit that Bislam Zarapi is not a JCE member and that JCE members would not openly discuss opponent policy with him, and then also argue that he was one of the people who attended each of the meetings in the zone where, quote, alignment with the targeting policy and field-level execution of the common plan were ensured. If Zarapi's presence at these meetings didn't make him a JCE member, then they don't make Thaçi a JCE member either. Slide 125. Thaçi actively promoted the achievement of the common purpose through his executive authority as Prime Minister of the PGOK. That's paragraph 485. But nothing cited in this footnote supports the assertion. This is yet another example of why I encourage you to go through the footnotes yourselves before you accept anything that the prosecution argues in its brief. The next significant contribution allegedly made by Hashim Thaçi is participating in, facilitating, encouraging crimes in furtherance of the common purpose. And the first allegation is that Thaçi ordered KLA members to assist him in the commission of crimes. And for this section, I need to go into private session, Mr. President.
Private session, please, Mr. Court Officer.
Your Honor, we're in public session. Thank you.
Let me go ahead.
Thank you. Turning now to the Chirz incident. If we could please have slide 145. It is undisputed that the parliamentary delegation in Chirz was detained for approximately 48 hours. For the reasons explained on this slide, detention of 48 hours cannot, in itself, violate fundamental international law. Slide 146. The evidence in the record shows that the detention was not part of a widespread or systematic attack against a civilian population. On the contrary, the KLA had military reasons to stop the delegation and question its members. You can see the references to that relevant evidence on this slide. If there is a reasonable doubt that the purpose of the stop was motivated by military objectives, such as a fear that the delegation had come unannounced to encourage surrender in a moment when Chirz was under attack, then this stop was not intended to further the alleged common criminal purpose of gaining and exercising control over all of Kosovo, and falls outside the scope of the SPO's JCE allegation. It does not matter if the KLA's intent to pursue a military objective lacked sufficient probable cause, because the improper pursuit of an intended military objective does not mean that the objective was a political one as described by the SPO's common criminal purpose. The next slide is not for public broadcast. Slide 147. The KLA's objective concerns are also reflected in contemporaneous documents, which you can see on this slide. At the 23 September 1998 press conference, and later in cross-examination, George Deadeye confirmed the KLA was concerned by the delegation's failure to inform it of its arrival. Okay. Slide 148, and this can be public. The KLA allowed the delegation to enter Chirz and speak to the people, just as it had previously allowed other parliamentary delegations in other areas. If the detention indeed were part of an organized attack against opponents, the KLA would not have permitted such visits or public speeches. And if there is a reasonable interpretation of the evidence that the stop was in pursuit of a military objective to stop the parliamentarians from encouraging disarmament in the middle of hostilities, then this stop falls outside of the JCE's common criminal purpose. Moreover, the SPO on Monday tried to suggest that a communiqué issued on 18 September was somehow connected to the Chirz incident. However, the KLA did not know there would be a visit to Chirz 2 days later, and initially allowed the delegation in and to speak to the people. The 18 September communiqué could not have significantly contributed to the Chirz event. Slide 149. The next slide can be broadcast to the public. Slide 154. For example, Deadeye stated that the delegation was treated correctly when he was speaking in the press conference on the 23rd of September 1998 and at a subsequent PLK meeting. You can see the relevant contemporaneous documents that corroborate Deadeye's trial testimony on this point on this slide. Slide 155. Another contemporaneous piece of evidence that confirms that members of the delegation were not seriously abused and confirms they had no visible injuries hours after their release. Crucially, the SPO was apparently not aware of the press conference video before the defense opening statement, which means the SPO brought these charges without looking at contemporaneous video to assess the credibility of Deadeye's 2014 ULEX statement. Slide 156. Unable to dispute the truth as captured on contemporaneous video, the SPO at trial tried to spin the video by claiming it showed Deadeye's bruising. We have the relevant part of the SPO's examination here on this slide. Slide 157. However, during our cross-examination, we demonstrated that what the SPO tried to pass off as bruising was actually a shadow from TV lighting. You have references to the relevant part of the transcript on this slide. We will now play a short excerpt of about 6 seconds from this video, Exhibit P00321, which demonstrates this point. Although there is audio, we're not interested in the audio, and interpretation is not needed for this. Thank you. Slide 158. Finally, on this slide, you can see a comparison between the part of the video the SPO showed to the witness during its direct examination and part of the video shown by the defense during its cross-examination. As the witness himself put it, the video shown by the defense actually shows his hand was, quote, as white as snow. Slide 159. The SPO knows that this video discredits its Chirz case. Yet the SPO did not say a single word about the video in an 870-page final brief. Nor did it say a single word about this video in its closing submissions, despite the prominence of the video given by the defense in opening statements, in its cross-examination of George Deadeye, in its final brief submissions, and despite the fact that the SPO wound up putting the video in evidence itself. The SPO's recognition of the powerful effect of that video on its case is evident when the panel recalls that in the SPO pretrial brief at paragraph 468, the SPO alleged that Deadeye, quote, was left severely traumatized by the detention. He still suffers from pain in his right arm and hand as a result, relying on Deadeye's 2014 ULEX interview in support of that claim. The next slide is not for public broadcast. Now, however, in its final brief, in paragraph 945, describing the, quote, victim impact of the events at Chirz, the SPO continues to cite to Deadeye's 2014 ULEX interview, P680, at page 034260, but now it has changed the allegation to a claim that Deadeye suffers, quote, chronic pain and hearing loss, injuries that would not be apparent to the naked eye and therefore not refutable by the Chirz video, and has completely dropped the claim that Deadeye still suffers or ever suffered pain in his right arm and hand as a result of the events at Chirz, as he had falsely claimed in his 2014 ULEX interview. The only reason that the SPO dropped this allegation that it made in its pretrial brief is because the SPO recognizes that the Chirz video discredits Deadeye's 2014 ULEX statement. The next slide can be broadcast to the public. In summary, the contemporaneous evidence shows that the delegation was not seriously abused in either Chirz or Baize, and there is no contemporaneous evidence from 1998 which shows that they were. At the same time, this evidence discredits Deadeye's previous statements, as well as statements of certain other members of the delegation, and creates, at the very least, reasonable doubt about their contents. The SPO, on the other hand, attempts to discredit Deadeye's admissions in court that his 2014 ULEX statement was substantially fabricated, arguing that either he was too afraid to tell the truth in court, or else suggesting that he was interfered with, although they have made no charges that any witness in this case was interfered with. But the problem for the SPO is that Deadeye's courtroom recantation of his 2014 ULEX statement is corroborated by contemporaneous evidence, including the Chirz video, which, as I've mentioned, the SPO tacitly has now acknowledged. He was not beaten badly on his arm, as he claimed to ULEX in 2014, and which the SPO now acknowledges. His courtroom recantation is corroborated and raises reasonable doubt about the veracity of his 2014 ULEX evidence. Importantly, because these reasonable doubts stem from the contemporaneous documents and video, they cannot be explained away by the witness's alleged fear, as the SPO alleges in its final brief. Slide 162. In fact, the SPO's assertion that the witnesses changed their testimony because of fear is not logical. The SPO essentially claims that Deadeye, as well as others, were not afraid to speak against Hashim Thaçi between 2001 and 2014, when Hashim Thaçi was actually in power in Kosovo and they were his political opponents, but suddenly became afraid more than a decade later, even though Hashim Thaçi does not have any political function in Kosovo and is being detained in The Hague. It is much more plausible that these witnesses made false statements when they thought they could politically benefit from them, but were not willing to defend these false statements once cross-examined in this case. Slide 163. Even if there was any mistreatment in Bajce, the SPO has not shown it was directed by Hashim Thaçi. On the contrary, the contemporaneous evidence again shows that Sabit Getzi was blamed by the delegation. This is reflected in diplomatic cables of the United States, where it's noted that Getzi is blamed, with no mention of Thaçi. I also note it is highly implausible that Rugova and other LDK leaders, with whom Sean Burns had frequent contacts, would not have said anything implicating Thaçi to Burns and others as Thaçi was being named leader of the Kosovo-Albanian delegation in Rambouillet, if the story was true. Slide 164. Finally, two additional points. First, for the reasons explained on this slide, which are addressed in more detail in paragraph 375 of our final brief, the SPO's torture narrative is unsupported. Slide 165. And second, the SPO failed to prove beyond reasonable doubt that Sabit Getzi threatened to kill Agim Krasniqi. On the contrary, Agim Krasniqi's own 2014 statement does not mention any such threats. And finally now I turn to the topic of the two detained so-called Serb journalists. The next two slides are not for public broadcast. Slide 166. There is a reasonable inference that the two Serb, quote, journalists were combatants and viewed as potential combatants. They were not detained because they, quote, opposed the common criminal purpose to take over Kosovo. The trial panel is familiar with the evidence that at least one of these two so-called journalists was a known Serb paramilitary from the Croatian and Bosnian wars and an arms smuggler as well as a suspected war criminal. That does not seem to be disputed in the case. If these two were in fact detained in pursuit of KLA military objectives, because they were suspicious or acting suspiciously, and because they had entered a combat zone without media credentials, then their detention was in pursuit of military objectives and not in pursuit of opponents opposed to the alleged JCE members gaining and exercising control over all of Kosovo. If so, then this allegation cannot be used in support of the JCE allegations in this case. The next slide may be broadcast to the public. Slide 167. Moreover, there is more than a reasonable inference here that Mr. Thaçi was not involved in questioning either individual. Neither so-called journalist identified Thaçi as having questioned him, and Radošević, under questioning by the trial panel, stated that he was questioned by someone speaking Serbian who was not using an interpreter. The SPO in its submissions on Monday simply ignores that evidence. Mr. Thaçi does not speak Serbian, and therefore there is reasonable doubt as to whether he was involved in questioning these individuals. And this is discussed more fully in paragraphs 379 to 383 of our final brief. It is not unusual that these individuals were not brought before a judge. They were detained in October 1998, immediately after the Serbian summer offensive had decimated the KLA, and just as a ceasefire was about to take hold. Slide 168. The KLA was in no position to focus on creating institutions of due process in the summer and fall of 1998. It was only after the October ceasefire that the KLA was able in November 1998 to commence a restructuring, including by creating institutions of due process. The April 2023 ICRC guidelines, discussed in paragraph 606 of our final brief, address this very dilemma of non-state armed groups and due process, and the ICRC has determined that while, of course, certain conditions of detention must be respected by the detaining party within the limits of their capabilities, the ICRC notes that, quote, it may take time and resources to define and implement effective review procedures. That is exactly what happened here. The KLA's ability to afford due process must be assessed in the circumstances in which it found itself, and not against due process standards in established states. Accordingly, there is reasonable doubt about the SPO's allegation that through the case of the two so-called Serb journalists, Mr. Thaçi made a significant contribution to the crimes charged. Briefly, I will address the allegation as it relates to Uk Batucci. The SPO also makes certain allegations concerning the cases of Uk Batucci and Avdil Rama. In the interest of time, I direct the panel to our discussion of these cases at paragraphs 346 to 352 of the Thaçi final brief. Slide 169. The SPO claims that Mr. Thaçi encouraged KLA members to, quote, fight against anyone who did not recognize the general staff or respect Thaçi's own orders as his KLA subordinates received, understood, and implemented his message. This allegation is based on the KLA General Staff's trip to Dukagin in early September 1998 and is addressed in paragraphs 141 to 145 of the Thaçi final brief. And in the interest of time, I will not repeat our reputation of this argument here. In summary, the incident involving Tahir Zemai was provoked by Tahir Zemai and Bukoshi's efforts to target the KLA for takeover by FARC across Kosovo, and in particular, in the Dukagin zone, and to have the Dukagin zone support Rugova as its negotiator with talks with Ambassador Hill, rather than support Adem Demaci, as had been the choice of the General Staff. The General Staff members, including Bislam Zarapi, came to Dukagin to prevent Zemai and Bukoshi from executing that takeover, and Mr. Thaçi did not use or encourage violence against anyone. Again, it bears emphasizing that Bislam Zarapi was present. Skipping to slides 171 for the interpreters. Next, the SPO argues that Thaçi made a significant contribution to the JCE by failing to prevent, investigate, and punish. The SPO alleges that criminal activity was ordered or approved directly by Thaçi or through the general staff. But the SPO cites no evidence to support this assertion. Instead, the SPO cites to the testimony of W04748, who did not claim that Hashim Thaçi issued or approved orders for criminal activity. They then also cite to the Chirz incident, but it does not support the claim for the reasons I've already stated. Skipping ahead to 173, and this may be public. The SPO alleges that Thaçi used his power as Prime Minister to appoint his co-accused and named JCE members to senior positions in the provisional government. First, there is no proof beyond reasonable doubt that Hashim Thaçi appointed anyone to the PGOK, as opposed to announcing the composition of the PGOK pursuant to a collective decision or a decision made by others. Second, the SPO has failed to allege, let alone prove, that Hashim Thaçi knew that any members of the provisional government had committed crimes. Slide 174. At paragraph 456, the SPO says that K4 did not receive any referrals from KLA leadership to investigate crimes committed by KLA members, despite having the capacity to do so, nor any indication that the KLA took disciplinary measures against those responsible. First, whether the KLA leadership made such referrals and took disciplinary measures is irrelevant to an assessment of Mr. Thaçi's significant contribution. What is relevant is Mr. Thaçi's personal actions. There is no proof beyond reasonable doubt that Thaçi had knowledge of specific crimes committed by KLA members who were his subordinates and which K4 and UNMIK did not know about. Indeed, Paul Williams, slide 175, told you that he does not recall anyone in the international community saying that Mr. Thaçi and the KLA needed to do more to investigate and prosecute crimes, and he himself, as the Kosovo-Albanian legal advisor, never told Mr. Thaçi that he had an obligation to investigate and punish. Next, the SPO claims that Mr. Thaçi contributed to the common criminal purpose through the dissemination of information to promote the common purpose and engender fear, distrust, and hatred. At paragraph 492, the SPO alleges Thaçi used the dissemination of information through public statements and the media as a mechanism to promote the common purpose to those KLA members who were to implement it. Slide 176. But the SPO has not done the exercise of showing how these alleged public statements or speeches contributed to the charged crimes, that there was a link or nexus between the dissemination of information in question and the charged crimes. The trial panel is required to consider this, as we can see in past JCE cases, where judges looked to the effect and impact of the accused's public statements and speeches. And I refer you to the cases cited on this slide. Slide 178. Again, political declaration number 7, and its language about a merciless blow and special warfare. There is no evidence as to who authored this text. The SPO has no credible evidence linking Hashim Thaçi to the preparation or dissemination of any communiques or political declarations, including this one. Even if they did, what is the causal nexus to any charged crime? What evidence have you seen that someone in the KLA actually read this political declaration and was inspired to commit one of the crimes charged in the indictment? Slide 179. The SPO alleges that Thaçi maintained the drumbeat that special warfare and opponents' activity required preventative and punitive measures. And here they cite Mr. Thaçi's November 1998 first television appearance. He doesn't say anything in the appearance insightful to crime. There is no established causal nexus to any crime. And his public appearance is shortly after the establishment of a military court to handle collaborators and Zarapi's 1D29 to treat civilians properly, which, as I mentioned, the SPO itself says came at a time when the KLA wanted to be seen internationally as complying with international law. There is no causal nexus and no furtherance of any policy. Next, at paragraph 494, the SPO alleges that Mr. Thaçi, as Prime Minister, continued to use his authority to equate domestic political dissent with actionable hostility, directing organizational resources towards continued promulgation of the common purpose. The sole evidence in support of this claim is in footnote 2037, namely that Thaçi and Veseli visited Kosovo Press on 12 May 1999 and expressed appreciation for its work. And a week later, Kosovo Press said its criticisms of certain political clans had the support of the KLA General Staff, the PGOK, and the government of Albania. As we say in paragraphs 253 to 255, the video of the visit does not reflect any evidence of Thaçi praising Kosovo Press. In any event, the SPO case is that because Hashim Thaçi expressed appreciation for the work of Kosovo Press in the middle of Serbia's ethnic cleansing of Kosovo and in the middle of NATO bombing campaign, this trial panel should use that as a basis to enter a finding that, quote, Thaçi continued to use his authority to equate domestic political dissent with actionable hostility. Respectfully, this is not a serious argument. Slide 181. At paragraph 495, the SPO claims that Thaçi personally made public statements designed to engender fear, distrust, and hatred of opponents. Multiple media outlets published a communique allegedly authored by Thaçi containing dangerous falsehoods designed to eliminate an opponent. Again, they're relying on Mr. Salimi's SPO interview, which is not credible and it concerns Communique 59, and it's not credible for reasons we've already stated. They also rely on two newspaper interviews of Mr. Thaçi's given in January and May 1999. There is nothing in those interviews to suggest that Mr. Thaçi wanted crimes to be committed against civilians, nor did any in the international community, which was closely scrutinizing Mr. Thaçi in the very time period of these interviews. Moreover, there's absolutely no evidence in the record of anyone in the KLA even reading these interviews, let alone evidence that a perpetrator of one of the crimes charged in the indictment read it and was inspired by it. There can therefore be no finding of a significant contribution to any charged crime. At paragraph 496, the SPO alleges KLA members understood that political declarations and communiques Thaçi and others promulgated functioned as instructions, including on matters concerning detainees. Here, the SPO only cites Remy's orders granting amnesty to detainees, in which he claimed to be relying, among other things, on KLA communiques. But as we pointed out on cross-examination of Remy, and you see that cross-examination on this slide, there are no such KLA communiques calling on zone commanders to issue amnesties, and the SPO has never identified any such communiques. If the SPO cannot point to any communiques calling for Remy to issue an amnesty, then the SPO cannot make the case that, quote, KLA members understood political declarations and communiques Thaçi and others promulgated functioned as instructions. And again, the SPO has no credible evidence that Thaçi was involved in issuing a single communique or political declaration. Slide 182. At paragraph 497, the SPO claims that Thaçi directed international messaging that denied, downplayed, or coded the targeting policy, while general staff statements and communiques continued to propagate the policy internally. This raises a lot of questions. How could the general staff statements and communiques propagate the policy internally? They were public. How could the internationals not see the, quote, targeting of opponents for crimes, but the KLA internally could? And how come Zarapi didn't crack the code and understand that the KLA was being asked through the communiques to target opponents for crimes? The next 3 slides are not for public broadcast. Slide 183. At paragraph 498, the SPO says Thaçi withheld information available to him about victims in an effort to hinder the investigation efforts of their families. The SPO has not established that Thaçi had any information that the family did not have. Finally, we note that Hashim Thaçi's meetings with family occurred after the indictment period and are also outside the temporal jurisdiction of this court and the temporal scope of the indictment. And therefore, none of Mr. Thaçi's statements after the indictment period can be used against him as part of an actus reus of any crime charged in the indictment. Slide 184. We note when the defense objected to SPO questioning of family meetings with Mr. Thaçi outside the indictment period, based on this court's lack of jurisdiction, the SPO proffered that it was not attempting to elicit that testimony in order to prove the actus reus of any crime, including enforced disappearance, but rather to prove his mens rea for crimes committed within the indictment period. The trial panel allowed the SPO to proceed based on the SPO's proffer. We object to lack of notice of the SPO's attempt to use that evidence of meetings that occurred outside the temporal scope of the indictment and temporal jurisdiction of this court and charge them as an actus reus of significant contribution to a JCE. Slide 185. At paragraph 499, the SPO claims that Thaçi's meeting with Human Rights Watch in November '98 internally legitimized and externally deflected from crimes of KLA members, advancing the common purpose. On the contrary, as we explain in paragraphs 271 to 277 of our final brief, there is a reasonable interpretation of the evidence that Thaçi relayed that information from the meeting with Human Rights Watch and Fred Abrahams, and a military court was set up. In the same month, Zarapi issued orders to try to stop any abuse of civilians, which the SPO itself admits was an effort to show the internationals that we were a disciplined army. That's SPO footnote 280. It is reasonable to infer that Mr. Thaçi passed along what he learned from Fred Abrahams, and it resulted in the General Staff attempting to improve its compliance with international law. The next slide may be broadcast to the public. During its closing arguments on 9 February, the SPO referred to this meeting with Mr. Abrahams and asserted that it constituted an example of Mr. Thaçi's own words and conduct demonstrating the, quote, thin veneer of pretense employed by JCE members to disguise the targeting of opponents and resulting crimes. I will just quickly note here that this is a misrepresentation. Nothing in the cited transcript of the testimony of Mr. Abrahams supports the argument that Mr. Thaçi was identified as speaking those words. And in fact, Judge Bartha specifically asked Mr. Abrahams that question, and he said he could not be sure who was speaking in the meeting. And you see that testimony in slide 187 and 188. We'll skip ahead to slide 191. In paragraph 501, this is for the interpreters at page 100 of my remarks. In paragraph 501, the SPO claims that Thaçi was leading the, quote, personnel council. At the outset, we note that there is no allegation in the indictment or the SPO pretrial brief alleging that Hashim Thaçi had any role in the KLA in relation to personnel generally or a personnel council specifically, and we therefore object to the lack of notice and the denial of Mr. Thaçi's right to be heard and to respond to this allegation. We would have, for example, explored this topic with Mr. Zarapi had the SPO given any notice that Mr. Thaçi that he was going to be linked to a personnel council. Slide 192. They cite no evidence that the personnel council ever functioned or that Hashim Thaçi ever participated. The personnel council was discussed at a January '99 meeting when Mr. Thaçi was out of the country, and there is no evidence that anyone ever communicated with Mr. Thaçi about personnel decisions while he was out of the country. The SPO organogram, this is slide 193, put the personnel directorate subordinate to Zarapi, and at paragraphs 172 to 184, the SPO alleges that through the personnel directorate, quote, the general staff approved, confirmed, appointed, and promoted trusted persons who had demonstrated their loyalty and commitment to the common criminal purpose, and demoted and replaced and removed those who had not. Slide 194. How could the personnel department have been implementing the common criminal purpose if it was subordinated to Zarapi, who the SPO says in paragraph 1432 was not in the same inner circle of the general staff as the accused, not trusted by KLA members, including certain members of the general staff, and was not someone that the opponent policy would be discussed with. They say, for example, in paragraph 176, that Halit Yaha, through the personnel directorate, participated in a battalion training course in February and March 1999, together with Bislam Zarapi and Kadri Veseli, where he lectured inter alia about special warfare. If Bislam Zarapi was not part of the JCE and was not aware of the common criminal purpose, then what exactly is the SPO suggesting about this training course? How could Zarapi, slide 195, a former JNA officer with no connection to the LPK, be responsible for ensuring loyalty and commitment to the common purpose through the personnel department? Skipping ahead to slide 197 on page 103, and this slide is not for public broadcast. The SPO then again cites to the Tahir Zemai incident as proof of Thaçi's alleged ability to enforce general staff decisions to replace Zemai with Haradinaj. But as noted in our final trial brief, which you see in the top excerpt on this slide, the testimony was that Ramush Haradinaj had voluntarily given up his post to Zemai, and ultimately it was Haradinaj's decision as to whether he would reclaim it, not Hashim Thaçi's. And Haradinaj did reclaim it. Haradinaj was nobody's subordinate. If I may use a sports analogy, Ramush Haradinaj was like a free agent football player who was free to sign with any team. And he ultimately chose to sign with the team from the general staff. Slide 198. W01493 directly refuted the SPO's argument. He made clear that neither Mr. Thaçi nor anyone in the general staff had the authority to make the final decision over whether Zemai would be replaced, and that it was ultimately Haradinaj who had the power to make the final decision. And you see that testimony on this slide. The next slide may be broadcast to the public, and we're skipping to slide 200. There's an allegation that Mr. Thaçi and the general staff collectively ensured that logistical support was available for the needs of KLA subordinates, including to run detention centers. That's paragraph 504. They cite to Zarapi's SPO interview, where he said the general staff provided logistical support to establish detention centers, but this appears to be after the restructuring. More importantly, there is no evidence cited that Hashim Thaçi personally provided any logistical support. Zarapi was actually providing the logistical support, but is not in the JCE, while Thaçi was not involved in providing the logistical support, and he is. Thaçi provided weapons, and this is the allegation. Thaçi provided weapons and said they were only for those who supported the general staff, and implicitly the common purpose, and those who did not were criminals. There is no evidence that anyone thought they were being supplied weapons in order to ensure that Thaçi, Salimi, Veseli, and Krasniqi, and others could take control of Kosovo for themselves. Nor is there any evidence that Thaçi was aware that weapons would be used to support the alleged common criminal purpose. Next, they say Mr. Thaçi made a significant contribution by coordinating and liaising between JCE members and tools. I will say this briefly. In this section, I call it the guilt by association section. They say he visited, for example, Lahi Brahimai at Jablanica with no further comment. There's no allegation that Mr. Thaçi knew of any crimes at Jablanica. And I note that Ramush Haradinaj was the zone commander where Jablanica is located and is not alleged to be a JCE member. Next, the SPO alleges that in order to ensure the furthering of the common criminal purpose, Thaçi visited sites where crimes of KLA members were being committed. He met with senior officials in Likot, Stranica, Malyshevo, etc., demonstrating his hands-on control over who would implement policy in the field. In the interest of time, I will simply say that the SPO cites no evidence that Thaçi had any discussions with anyone at these locations about collaborators, detainees, or the need to target so-called opponents. They cite no evidence that Mr. Thaçi controlled anyone in any of these places or that he had any discussion with anyone about the alleged common criminal purpose. Need I mention again, Zarapi was present for many of these meetings. And I will switch now briefly to address the next topic of Mr. Thaçi's command position. We reiterate our position as stated in our brief that the SPO has failed to prove any of the elements of command responsibility that would make Mr. Thaçi responsible under that mode of liability. We only wish to highlight some additional points arising out of the SPO brief and closing statement. Slide 204. On Monday, you heard Mr. Tiger discuss the case of the Belachevac minors. I will summarize my remarks here to say that the SPO, in its brief, you see the slide 205, in its brief says that Mr. Thaçi, or alleges that Mr. Thaçi and Mr. Veseli were at Belachevac on the 17th of June, 1998. The SPO then goes on at paragraph it's slide, same slide. In the same brief, at footnote 1653, the SPO cites the evidence of the disappearance of the minors, all newspaper articles which say that didn't occur until the 22nd of June. So it's not clear to us what the SPO is suggesting about Mr. Thaçi and Mr. Veseli allegedly being present 5 days before any disappearance took place. And the SPO then went on to discuss a meeting between Thaçi and Veseli with an international in the aftermath of the Rahovec attack. Again, I will summarize by saying the SPO again simply chooses to ignore the trial testimony of the witness, Mr. Kickert. The witness said he could not recall whether there was a discussion about the Geneva Conventions. And moreover, the contemporaneous memo he wrote about that meeting contains no reference to any discussion about detentions or the Geneva Conventions. Finally, we go to slide 209. Mr. Thaçi's role as Prime Minister of the Provisional Government. Slide 210, we note simply for the record that there is no allegation by the SPO in its brief that there is evidence of Recep Salimi reporting to Mr. Thaçi or receiving orders from Mr. Thaçi as Minister of Public Order, and no allegation that Salimi, as Minister of Public Order, was Thaçi's subordinate during the PGOK period or at any other time. At slide 211, they claim at paragraph 298 that Mr. Thaçi appointed Salimi. However, their citation to support this claim in footnote 1230 does not demonstrate that Thaçi personally made the appointment. Slide 212, we note for the record that the SPO has not provided any evidence of any meetings of the PGOK in the summer of 1999. And finally, slide 213 and 214, the SPO makes no assertion that Hashim Thaçi was actually Commander-in-Chief. There is no evidence of any orders from him or reports to him, no evidence of any reports from him in any police line, be it military or Ministry of Public Order, to him, or orders from him to them. Mr. President, at this point I would ask leave from Ms. Tavakoli to address you on the provisional government, and then I will return in the afternoon.
Yes, you may go.
Thank you.
You may proceed, Ms. Tavakoli, whenever you're ready.
Thank you. The prosecution's case is that the provisional government was one of the structures and mechanisms of power created, enforced, and/or controlled by the accused to further the common purpose. It was, in their words, a vehicle through which to execute and accomplish their common criminal plan. 3 factors create a reasonable doubt that this was ever its purpose: its multi-party makeup, its international backing, and the reality that it could never be a real mechanism of power, as there was no country called Kosovo over which it could govern. As set out by Mr. Misetic, the PGOK was a multi-party government from its outset.
Could the speaker kindly be asked to slow down?
As set out in paragraph 25 of our final brief, its establishment was supported by the US, the UK, and other European nations as a way to unify the diverse Kosovan Albanian constituencies. This international support, in and of itself, raises a reasonable doubt that it was created as a vehicle to execute a common criminal plan for the accused to take over Kosovo. Unless, of course, the SPO is alleging that the United States, the United Kingdom, and Europe were supportive of such a criminal plan. Or are they asserting that it was a massive failure of Western diplomatic and intelligence services who didn't realise that that was its purpose? Had our 29-year-old client duped them all? Third, on any view, and as set out in our brief at paragraphs 564 to 566 and 577, the PGOK was always an aspirational endeavour, as the so-called government could not lead a country that did not yet exist. Security Council Resolution 1244 vested exclusive authority to run Kosovo in UNMIC, thus cementing its fate. Turning now to the specific actions of Hashim Thaçi that the prosecutor alleges that he made a significant contribution to this JCE via. Firstly, becoming the Prime Minister. Secondly, in this capacity, making political appointments and passing legislation. Thirdly, contesting unmixed authority under 1244 by asserting the primacy of the PGOK. And finally, by being aware of the crimes committed in the summer of '99, but failing to prevent or punish them. Thaçi held the position of the Prime Minister, but what real power did that bring him to effect any common plan to seize control of Kosovo, when the international community didn't even recognise that position? He could not even send a letter to UNMIC in his capacity as the Prime Minister, because they returned those letters pursuant to an official policy. That's Exhibit 1D00361. He could not sign any significant commitments binding the Kosovars in that capacity. As John Duncan testified, he could not sign the undertaking to demilitarise the KLA using the title of Prime Minister, as the Allied powers would not accept it, as they were not ready to recognise Kosovo, and they were certainly not ready to recognise Hashim Thaçi as the leader of Kosovo. In reality, it was a meaningless title for an office in a state that didn't exist. It was not a vehicle through which a JCE could be implemented. Now, the SPO allege that in his capacity as Prime Minister, he passed legislation and made political appointments, which were a significant contribution to that criminal purpose. However, the SPO has not established beyond a reasonable doubt that he personally issued PGOK laws and decrees over aspects of civilian governance. At paragraph 44 of our brief, their brief, the prosecution cite to additional documents to those relied on in their pre-trial brief, which we dealt with at paragraphs 213 to 228 of our brief, which I won't repeat here, to support that allegation. These new documents don't take them any further. None of the PGOK decrees or related documents listed is signed by Thaçi, nor do they even mention him. None of the reports from international organisations that PGOK initiatives extend to trying to levy taxes make any mention of Thaçi and his involvement in or awareness of activities. And none of the reports of governance at a regional level mention Thaçi or actions by the PGOK. They reflect local initiatives. But even if your honours were to find for the prosecution that he did issue legislation, where does that take them? None of the alleged legislation was criminal, and there is no evidence beyond a reasonable doubt that it entered into effect. The fact that Thaçi may have told a journalist at the end of July '99 that the PGOK had achieved a horizontal and vertical spread of government in all of the municipalities doesn't make it true. And indeed, this court heard credible international witnesses who were on the ground at the time who said that the PGOK was never a fully functioning government, and any alleged attempts to make it appear so were simply aspirational. Turning to his appointment of ministers, Mr. Misetic has addressed you on this, and I will not repeat it. To the extent that there are allegations concerning new appointments, for example, that of Jakub Krasniqi and others, we rely on the same evidential basis to refute those claims that we did in our brief. For any appointments based on P00813, see paragraphs 208 to 209, for use of 1D 00070, see paragraph 210, and for reliance on the untested statement of a co-accused. See paragraph 119. In any event, notwithstanding any finding that Your Honours may make about who appointed Thaçi's co-counsel to so-called ministerial office, the prosecution has not proven beyond a reasonable doubt that Thaçi exercised any authority over them. The record contains no orders from Thaçi to them and no reports from them to Thaçi. The prosecution's allegation that he appointed mayors is similarly tenuous. There is little direct, credible evidence that he did so. Mainly it's hearsay of individuals telling others that Thaçi had appointed them. But again, even if Your Honours are persuaded by the prosecution's argument, where does it take them? These appointments were not in and of themselves criminal. Despite this, to the extent that there was an effort by the PGOK to stand up some sort of a government, be it by drafting or issuing legislation or appointing local or national politicians, it's a reasonable possibility that this was to try and get some sort of civilian administration up and running following the complete collapse of basic services when the Serbs left, rather than any attempt to seize control of the country. Indeed, this court had extensive evidence from internationals, some of whom will be named on this slide, including John Duncan, WO2135 and WO2161, that when the war ended and the Serbian population largely left Kosovo, the governance structure completely collapsed, as it had been staffed predominantly by Serbs, the Albanians having been forced out of their jobs during the apartheid rule of Serbia. Faced with this reality, it's a reasonable possibility that Kosovo Albanians, including those in the PGOK and UCK, try to get the society working again. Indeed, WO2161 testified that the UCK tried to find Albanians to run the electricity, the sanitation, the basic services, as nothing was functioning when the Serbs left. Turning now to the allegation that Thaçi contested unmixed authority. We don't deny, as Jock Covey testified, that in the early days of the UNMIK mission, Thaçi jockeyed or vied for influence with UNMIK, and he tried to assert a role for the PGOK in the governance of Kosovo. However, ultimately, he turned towards and cooperated with UNMIK. It's also important to remember that there were at least 3 governments in Kosovo at that time. There was the PGOK, the Bukoshi government, and the Serbian government office in Pristina. None of these were legal, pursuant to 1244, but the prosecution doesn't allege that the other 2 were vehicles for a JCE. Rather, it says that the LDK were the victims of the PGOK's JCE. Pursuant to 1244, it was UNMIK that legally ran Kosovo. So any attempt by Thaçi to seize power and control meant that he had to seize it from UNMIK, who had been granted their authority by the UN Security Council. The evidence of veteran American diplomat Jock Covey, the deputy head of UNMIK, that this was never Hashim Thaçi's intention, in and of itself raises a reasonable doubt that seizing control was ever Thaçi's aim, even when, in the early days of the administration, he was competing with UNMIK for authority. Indeed, as captured in this slide, Covey testified that he and Bernard Kouchner, who when they were deployed had decades of experience in this kind of work, they expected that there would be some kind of a contest, a push and a shove, a testing of UNMIC to see if it was capable of administering. And in that regard, Thaçi lived up to their expectations. And in Covey's words, he initially attempted to legitimize the claims of the PGOK to administer Kosovo in direct contradiction to the mandate of the UN Security Council, before relenting and realizing that his interests were best served by cooperating with UNMIC. Indeed, that Hashim Thaçi ultimately recognized and respected the authority of UNMIC was confirmed by the SRSG Bernard Kouchner himself in a cable on the 16th of November 1999, which is set out in this slide. And he stated that all leaders, which includes Thaçi, accepted my special role as SRSG, thus as legislative authority and ultimate decision maker. Now, turning back to the early days of UNMIC's mandate, Covey was unsurprised by the way that Thaçi initially competed with UNMIC's mandate, as in his words, as set out in this slide, they were dealing with someone who was very young, and who was trying to seize an opportunity that he thought he saw. Why would he be surprised that this is the way he would act initially? It was nothing more than a very young, highly ambitious future politician trying roles for size. As your honours know, this is what politicians do. They posture, they position themselves, and they try to appeal to different audiences and constituencies for their current or future political gain. The prosecution has a very difficult burden of proving to you, beyond a reasonable doubt, where Thaçi was posturing and where he was not. What was his actual intent? One reasonable explanation of Thaçi's behaviour towards UNMIC in the early days was that he was trying to build a power base for a future lifetime in politics, because in Covey's words, at 27594, he knew he didn't have that power at the time. And your honours will recall, if you look at Exhibit 1D00216, that the summer of '99 immediately preceded Thaçi's establishment of his own political party on the 10th of October 99. However, there came a point, as Durkee and Covey testified, where Thaçi realised that his ambitions were best served by cooperating with UNMIC, which he did. And the references are T27953 to 4, 1D00390, paragraph 69 to 71, and 1D00428, paragraph 19. Now, ultimately, as set out in this paragraph of Jock Covey's statement, Mr. Thaçi played a very constructive role to advance UNMIC's peace-building aims, including by accepting that the provisional government of Kosovo, of which he was the Prime Minister, became irrelevant upon the arrival of UNMIC, accepting appropriate roles within the new joint administration structures, routinely sharing power and credit with figures he had once denounced, and accepting his party's defeat in municipal and local elections. Your Honours, does a man who agreed to and did demilitarise the KLA, who abandoned, according to Jock Covey, at 27527, any pretense of a government to work constructively with UNMIC post-war, including by supporting the implementation of the KPS, and who later, in October 2000 and November 2001, stood and lost in 2 democratic elections, conceded defeat, and kept going till he won an election in 2007, fair and square, really sound like a man who was trying to seize control of Kosovo? The defence submit that it does not. The SPOK simply doesn't fit the facts. They have overreached. That's a convenient place to stop.
We'll be adjourned for lunch until 2:30. We are adjourned.
All rise. All rise.
Be seated. Ms. Stavicoli, you still have the floor.
Right, thank you. I turn now to the prosecution's final argument, that Hashim Thaçi demonstrated his intent and made a significant contribution to the common plan in the summer of '99 by failing to prevent or punish the crimes. I will not repeat what we've said in our brief here, save to underscore that the SPO have not established, beyond a reasonable doubt, that Thaçi was put on notice of the crimes in the summer of '99 in anything more than general terms. You can see our brief references 288 to 289, 294 to 296, and 607. Or that he had effective control over the alleged perpetrators such that he could prevent or punish those crimes. And that's in our brief at paragraphs 456 to 595 and section VC3. On Tuesday, the prosecution highlighted a meeting on the 27th of July 1999, where Hashim Thaçi was described as being evasive on criminality, and this was in respect of the PU crimes, of alleged PU crimes. As stated in paragraph 296 of our brief, Covey, who attended this meeting, described Thaçi's alleged vague and temporizing responses as consistent with the understanding that he had, and I quote, very little influence, but was reluctant to say so. Another participant, WO2183, who was also in attendance, whilst interpreting Thaçi's evasive answer as an attempt to minimize responsibility, couldn't confirm that Thaçi or Cheku had direct control over the black-shirted policeman or the Atlantic Brigade. In any event, following the passage of UN Security Council Resolution 1244, UNMIC was the only body that could punish crimes. Hashim Thaçi could not. Now, turning to what Hashim Thaçi could do, he could speak out, and he did. As detailed in our closing brief, paragraphs 409 to 417, the trial record is replete with multiple examples and multiple statements of Thaçi speaking out against the violence and asking for stabilisation within Kosovo and for the Kosovo Serbs to stay, and also taking concrete steps in the same vein. For example, accompanying the SRSG to use his influence to calm the Kosovo Albanians demonstrating in Mitrovica and visiting Serb victims of the violence with Kushner, which Covey testified at 27611, and in quotes, might have put a bullseye on his back. Covey was clear when asked questions by Judge Bartha at 27610 that this was not just virtue signalling, given the significant personal and political risk that such actions exposed Thaçi to. It is our case that such statements and actions by Thaçi, which General Clark considered genuine, raise further doubt that he had the intent to seize power and control in Kosovo by committing crimes. The prosecution argue the opposite. They say, in their final brief, that such statements in the summer of '99 fail to negate Thaçi's intent because they were aimed at advancing his own goals, were made in response to pressure from internationals, and were made simultaneously with contrary action on the ground, i.e., the continued commission of crimes. Yes, making these statements did advance Hashim Thaçi's own goals, because, as already stated, his interest lay in cooperating with the international community. Yes, sometimes he made them when having been asked to do so by internationals. But every statement he made put him at significant personal risk, and yet he made them all the same. The fact that crimes continued, despite Thaçi's statements, doesn't negate his intent as alleged. Indeed, the prosecution's case in this regard appears to be built in a large part on the evidence of WO 2183, who at that time was a junior international in his second foreign posting, who struggled to understand why, notwithstanding Thaçi's position as the Prime Minister, his public statements didn't stop the violence. And he concluded that Thaçi must have tacitly condoned it. It's worth recalling at this juncture the evidence of a much more seasoned hand, that of Jock Covey, who stated that many in UNMIC were taken in by Thaçi's pretense to power. And we suggest that that included individuals like WO 2183. And you'll see on the slide paragraph 72 of Covey's statement. Mr. Thaçi's instincts and pretense to power may have been politically useful before Kosovar audiences, but they were misunderstood by some within the human rights community, including human rights specialists in UNMIC, who inaccurately concluded, based on Mr. Thaçi's efforts to portray himself as leader, that he actually had the power to control violence perpetrated by elements of what had always been a highly decentralised and now former KLA. For all of us on the ground, it was clear that Mr. Thaçi's ambition far outstripped his actual influence over the KLA. Indeed, under cross-examination, WO 2183 conceded that he didn't know the command and control structure of the KLA and was not qualified to opine on military matters. And that's at 23889 to 23890 and 23977. We submit that it's a reasonable possibility that the reason violence continued in the summer of '99, despite Thaçi's calls for tolerance, was precisely because he didn't have the power over the perpetrators to stop it. Now, whether this was because the crimes were being committed by former or current KLA members, organised criminal groups, returning refugees, none of whom the SPO has proved he had effective control over. Indeed, as discussed at paragraphs 34, 416, 586, 636 and 654 of the defence brief, this was also the view of NATO and its member states, as expressed by General Clark, John Duncan and Michael Durkee. Individually or collectively, their evidence raises a reasonable doubt that Thaçi could have prevented or punished the crimes in the summer of '99, regardless of whether or not he knew about them. And it's for all these reasons that the prosecution has failed to establish, beyond a reasonable doubt, that Thaçi used the PGOK to execute the alleged common criminal plan. And now I'm going to hand the floor to Ambassador Prosper.
Thank you, Ms. Stavakoli. You may proceed, Mr.
Thank you.
Prosper.
Good afternoon. Well, I will need to be brief in order to save some additional time for our lead counsel. But I want to talk about the defense witnesses, the internationals, and the attacks that occurred during the course of these closing arguments against them. I'm going to speak broadly and briefly. But let me begin by, yesterday I had an exchange with a friend, a senior diplomat, a multi-time ambassador, a former special envoy, and I read to him quotes that you heard from Monday, particularly from the specialist prosecutor. The quote in particular is, the court heard live evidence from 7 defense witnesses, all international. Each was involved in discrete efforts to bring peace and administration to Kosovo. But whether their involvement in this case and their limited observation are valuable for the purposes of this court is an entirely different matter. For the most part, the 7 international witnesses parachuted in to a situation with little background knowledge of the players involved, did not speak the language, interacted face-to-face with key players only a handful of times, hardly, if ever, saw any KLA rules, regulations, orders, or communiques, and were not familiar with KLA structure. And as she goes on to say, they had a scant layer of information. My friend and colleague responded by saying, geez, a wee bit dismissive of my profession. Gentlemen, I think we need to look at this because these comments display a level of arrogance and condescension that has plagued these proceedings from the very beginning. To dismiss out of hand the testimony or the experiences of these experienced professionals whose job it was to go and analyze and assess a situation, to look at the events in order to preserve and protect international security, is reckless. In fact, it's wrong and perhaps even an act of desperation. It's no wonder governments are leery of tribunals, international tribunals. When you have their professionals that come and tell you how it was, what was happening, and it's rejected by someone or people that weren't even there, this is highly problematic. We need to keep in mind that these institutions, these tribunals, are a tool of the international order, the international system. The people that came before you are part of that order. They are the ones that decide whether there should be tribunals and should be justice. Think of the ramification if we just say, hey, they don't know what they're talking about. You were there, but it doesn't matter because we will interpret it differently. Don't believe your eyes. Don't believe your ears. We know better. I think it's important for us to remind ourselves of these witnesses. Now, you may not like them, and you don't need to. You may not respect our international witnesses as individuals, and you don't need to. But you do need to respect their roles, their professions, and who they represented. The United States government, the British government, NATO, and the United Nations. These individuals did not come here simply in a private capacity to say, here is what I think. They spoke with you or to you on behalf of their experiences and essentially on behalf of their institutions. Why else did we need to get clearance for them to be able to speak? Because the information they possess belongs to those institutions. So when they gave you their views, they were considered views. They were the product of collaboration, collating information from defense, military organizations, from the intelligence community, from reports from NGOs, from internal debates, from personal observations in the field, from in-field briefings. So you had a complete considered view. Jamie Rubin, a staffer on the Foreign Relations Committee for Senator Biden, advisor to the Secretary of State. In fact, he was tasked, as a result of being in every meeting with the Secretary, he was tasked to go and find out who Hashim Thaçi was. Go spend time with him. And you recall from his testimony that he at Rambouillet, at every opportunity, would go and have a cigarette with Mr. Thaçi, would be there in the room. He got a chance to observe and gave you his views. Professor Paul Williams, an esteemed professor at an American university. Now, he's very interesting because you have an individual who is assisting fragile states and governments in pursuing peace and building democratic societies, and he does it pro bono. He was there. He was in the room. He heard the conversations. He saw the interactions. And he came here, as the others, voluntarily to give you his perspectives. This cannot be dismissed. John Duncan, Ambassador John Duncan, Mike Durkee, senior diplomats in their own bureaucracy, decades of experience. Durkee, a military veteran, it rose to a level of trust where they were sent to NATO to represent their countries and be the political advisor. They studied these issues day in and day out. Jacques Covey, appointed by the Secretary General, former Deputy National Security Advisor, seasoned diplomat, gave you his views. And yet they want to dismiss their experiences. We know Ambassador Hill, 6-time ambassador, and we can go on and talk about his other experiences. But the most important part was he was the special envoy for Kosovo with one responsibility: to find out who is who, what is what within the Kosovo-Serbia issue. That was his job. But the prosecution wants you to believe that he parachuted in. He only had scant information. Come on. Is that believable? When the President of the United States, the contact group, which is the United States, UK, France, Italy, Germany, Russia, they all need to know who is who and what is what. Do you believe that they would go back and say, hey, Madam Secretary, I only have scant information. I know you are about to decide whether or not to go to war, but here's my mere impressions, as the prosecution wants you to believe. And of course, General Clark, West Point grad, Rhodes Scholar, 4-star general, was at Dayton, as was Ambassador Hill, Supreme Allied Commander, Commander of U.S. forces in Europe. He gave you his views, considered views based on all the information from intelligence, from political meetings, and so on that would percolate up. Recall, he said he read everything, and he formed a conclusion and shared it with you. These people had personal interactions. They were not on solo missions. They were not on some tourist or safari to Kosovo. Now, the prosecution wants you to believe that they were maybe just passing by and just made some scant observations. They want to minimize their role. That is disrespectful. These people are serving their country, serving their institutions. This displays an ignorance, if you will, as to how the process works. These diplomats, these experts, this is their life work. And they came here voluntarily to talk to you, to say, this is what I know. This is what I saw. These are my expert conclusions. And we're just going to toss it away? Your Honors, I think we need to remind ourselves that public servants have a role. Public servants have something to offer. We, as lawyers, in looking at things hindsight, do not know everything. So you have to trust the people that were there. In fact, I think it's also important for us to look at this in the historical lens. They were working on consequential issues. This was 1999, and please bear with me. Just a few short years earlier, we had an event in Somalia where the international community committed troops, and we lost 18 U.S. service members and had 11 international UN casualties, whether killed or injured. This shocked the peacekeeping community, so much so that a year later, less than a year later, in Rwanda, the world sat by and watched out of fear of the unknown, and 1 million people were killed in 100 days. It shocked them so much so that a year after that, in 95, Dutch forces in Srebrenica watched as 8,000 men and boys were killed because they were so afraid to do anything and lose service members. So now in 1999, all that changes, and the international community decides on scant information, hey, we are going to go to war. We are going to go to war against Serbia without knowing who is who, without knowing who the KLA is. Are they friends? Are they foe? Can we work with them? What is their organization? Who's in charge? Who do we talk to? Of course they asked these questions. They had to. So when these witnesses came here and 26 years later share this information with you, while part of it obviously is based on reflection and memory, you have to know that at the time, the information was real, it was solid, it was not scant, and it was not mere impressions. Now, earlier, Mr. Howling said something very interesting. He essentially, and I'm going to paraphrase, but he essentially made the point that the internationals, Jamie Rubin, Wesley Clark, were essentially duped by 29-year-old Hashim Thaçi. Do you really believe that? We have a man who's just was recently a student, spent time in Switzerland, would be able to dupe these esteemed people that we have talked about? Of course not. Now, all these witnesses came here, and they all shared something with you. They said there was no effective command and control of the KLA. There was no political structure. Hashim Thaçi was not in charge, and the armed conflict ended in June '99. The SPO does not want you to focus on that. In fact, so much so that they didn't even call these witnesses who were all over the records that have been in these proceedings. They chose not to interview them. They chose not to even call them. Instead, the prosecution comes here today and basically engages in evidentiary gymnastics, trying to twist and turn the facts, contorting, hoping that you don't see that they have missed the mark, that they have not stuck the landing. They have the burden of proof. And we need to remind ourselves that this burden of proof is extremely high, beyond a reasonable doubt. I ask you to reflect back when you were either in law school, a young lawyer, a young judge, and you learned about this burden of proof. You learned about how important it was and how high this bar is to prevent overreach, to ensure that if we are going to deny someone of their liberty, if the government is going to do that, or an authoritative body is going to do that, that we are sure, that we are convinced. The international witnesses are walking reasonable doubt. You take them one by one. Jamie Rubin, he was there. He told you about his experiences, Rambouillet, and demilitarization. Paul Williams, he was there. He told you what he saw. John Duncan was in the room, said the zone commanders were leading the way. He was there. Mike Durkee, he was involved, read all the information, and was there with meetings with Hashim Thaçi, with the Supreme Allied Commander. Christopher Hill, walking reasonable doubt, up and down. They don't even comment on his testimony. General Wesley Clark, his title, his position speaks for itself. And the man was able to tell you what he saw. You believe one of those witnesses, that's it. However, take them as a collective, end of story. They all come from different walks of life. They corroborate one another, and they send and share with you the exact same picture, that Hashim Thaçi is not guilty of the charges for which he has been brought to these proceedings. The prosecutor concluded in her remarks that the KSC is becoming a regular and conventional court. I fear that instead of this court being a model of what we want the rule of law and courts to be, because of this prosecution, it is becoming a symbol of what we're trying to prevent. So this case will be in your hands. I invite you to read the testimonies of these international witnesses, these people whose life work was made available to you and were able to share real stories from the real world about what happened in 1998 and 1999. Thank you.
Thank you, Mr. Prosper. Mr. Misitich, I understand we get some more from you.
Yes, in case you haven't had enough of me, 30 minutes to go. I will move away from the facts, and I would like to make some brief submissions on some legal and evidentiary aspects of the case. Starting with, in slide 224, the first thing we were struck by when we started reading the SPO's final trial brief, namely the extent to which the SPO's case relies on untested evidence. Slide 225. Although the trial panel heard from 130 live witnesses in this case, the SPO's final trial brief and their final submissions rely to an overwhelming extent on other material where the authors or purported authors were not called or examined, and in some cases remain unknown. Some statistics. Starting with the accused's own formal prior statements. The accused in this case did not testify, as is their right. They did, however, cooperate through giving interviews with the SPO or other prosecutorial authorities, which were not subjected to testing or cross-examination, and were admitted over objections. The SPO relies on the accused's untested formal statements more than 1,100 times to try to prove their case. You see the statistics. Actually, I can read them out. Mr. Salimi's prior statements are cited 499 times. Mr. Krasniqi's prior statements are cited 274 times. Mr. Thaçi's prior statements are cited 229 times. Mr. Veseli's prior statements are cited 100 times. And this is before we consider their other informal statements, including the hundreds and hundreds of citations to other interviews, books, both published and unpublished, or documents they prepared, which Mr. Thaçi was unable to confront and test. For example, one book written by Mr. Krasniqi was cited 271 times in the SPO final trial brief. Other post-war books, manuscripts, or documents allegedly drafted by Mr. Krasniqi are cited more than 100 times, and informal interviews with Mr. Salimi are cited 80 times. Slide 226, please. This is a pattern. The SPO has attempted to build a case on documents, manuscripts, interviews, press articles, all admitted through the bar table and not tested in this courtroom. This is trial by hearsay. The danger with this is the evidence you heard from witnesses who were cross-examined and testified under oath about the propaganda and half-truths and exaggerations that affected the reliability of materials and documents that were created during the war, and which also affected the accounts that were created afterwards. Sokol Bashota explained this phenomenon to you when he was shown documents purportedly authored by Mr. Salimi, Mr. Krasniqi, and others, explaining that people exaggerate in these books for many reasons, to glorify the process of wartime, for their own ego, or for their own political purposes. Similarly, Mr. Kurtai walked away from his own published book, calling them exaggerated and unreliable, yet his book is cited 31 times in the final brief. This is made worse by the fact that untested materials often originate with allegedly key KLA members or named JCE members or international observers whom the SPO could have called but to authenticate these materials, but chose not to. Slide 227. I would like to refer back to this panel's decision admitting these statements of the accused, F01917 at paragraph 218, in which it is stated that, quote, Rule 140, subpart 4, subpart A, provides that a conviction may not be based solely or to a decisive extent on the statement of a witness whom the defense had no opportunity to examine. And you see the panel's decision there highlighted. But the panel went on to say that because the accused could elect not to testify, the panel will pay particular attention to the existence or otherwise of corroborating tested evidence before relying upon the statement of an accused in respect of a co-accused, in particular in relation to any critical or material aspect of the prosecution case. Now, there seemed to be some suggestion yesterday that you didn't need tested evidence, which is in direct conflict with your own ruling on admitting the statements of co-accused. These statements lack independent corroboration through tested evidence and cannot be relied upon against Mr. Thaçi. Slide 228. One significant example is the proposition in paragraph 1477 of the SPO final trial brief. I've showed it to you earlier. That says that principal responsibility for Communiqués rested with Thaçi and Krasniqi. I have already taken you through why the sources in the relevant footnote, footnote 6234, do not substantively support the proposition, including failing to establish beyond reasonable doubt that Hashim Thaçi had any involvement at all in the preparation of communiques and political declarations. We now also note that Mr. Thaçi has not been able to test the single piece of evidence cited by the SPO to support its claim that, quote, primary responsibility for communiques rested with Thaçi. Specifically, Mr. Thaçi has not been able to cross-examine Recep Salimi and dispute his suggestion that Mr. Thaçi was somehow involved in the preparation of Communiqué 59. To the extent the SPO suggests in footnote 6234 that Mr. Salimi's SPO interview is corroborated by a Facebook post of Mr. Krasniqi's, and I note that we dispute that it is corroborative, the same issue applies. Mr. Thaçi is not able to test Mr. Krasniqi either. We also refer you to other examples, including the propositions in paragraph 230, footnote 940, paragraph 266, footnote 1096, and paragraph 503, footnotes 2056 and 2057. This list is by no means exhaustive, and we urge you to carefully review and identify all propositions in the SPO final trial brief, which are supported only by evidence from Mr. Thaçi's co-accused, whether formal or informal statements, and whom he has been unable to effectively interrogate. Slide 229, please. Let me turn to modes of responsibility. I wanted to make some brief submissions on JCE. Slide 230. Our starting point for the JCE case is that the alleged common criminal purpose in the case did not exist. There was never a criminal plan to gain and exercise control over all of Kosovo through the commission of the charged crimes. Even if the SPO had established the existence of this common plan beyond a reasonable doubt, it must also prove Mr. Thaçi's significant contribution, but specifically a significant contribution to what exactly? Throughout its brief, the SPO alleges that the accused made a significant contribution to the common plan, for example, at paragraphs 471, 481, and 570. However, the position at this court is that for JCE liability to arise, the SPO must demonstrate beyond a reasonable doubt that Mr. Thaçi made a significant contribution to the crimes for which he is found responsible. In other words, Mr. Thaçi must be found to have contributed significantly to the commission of the charged crimes, murder, torture, cruel treatment, etc. And this is the consistent language which you see on your screen in the judgments of this court, including in our confirmation decision, F0026, paragraph 110. Slide 231, please. To be clear, the relevant case law establishes that participation in a JCE may take the form of contribution to the common purpose. However, this same case law takes this a step further and also stipulates that this contribution, quote, should at least be a significant contribution to the crimes for which the accused is found responsible. This next step is a crucial one, and the SPO has missed it, both in their submissions and in their presentation of the evidence in this case. Whole sections of the SPO brief are dedicated to whether the accused made a significant contribution to the common purpose, but with no submissions on how Mr. Thaçi's alleged acts and conduct contributed to the charged crimes. The question, which the SPO has never answered, is how did Hashim Thaçi make a significant contribution to killings and unlawful detentions? How did he make a significant contribution to torture? Particularly when, as the evidence shows, he was out of the country for much of the indictment period, and that many of the perpetrators were acting on the basis of personal motives and out of revenge. On Monday, the SPO told you that other motives, quote, do not negate the common purpose or even necessarily remove any particular crime from its scope. Indeed, a direct perpetrator need not share or even know of the common purpose. That's true. We have never said that JCE law requires that each of the perpetrators must share or know of the common purpose. But the SPO is required to demonstrate, beyond a reasonable doubt, that Hashim Thaçi made a significant contribution to the charged crimes. The prosecution, in closing, claimed that the SPO's final brief sets out, quote, in detail, in Part 3, statements of the JCE members which correspond to subsequent attacks or crimes on the ground. That's at transcript page 28428. This is just not true. The SPO has never done this exercise in relation to Mr. Thaçi by pointing to evidence that shows that speech, this public statement, corresponds to these subsequent crimes. And this link is needed. Ms. Lawson told you that there needs to be a, quote, sufficient link between the perpetrator in question and a JCE member, transcript page 28424. If the perpetrators were acting on the basis of their own personal motive and not because of something Mr. Thaçi did or said, where is this link? In reality, if you have people who are on the ground committing crimes for personal reasons, because of a property dispute or for revenge for past violence against their own family, this raises reasonable doubt to the SPO's claim that this person was being used as a tool of the JCE. And that is what undoubtedly removes those crimes from the JCE's scope. Slide 232. I also want to briefly address an issue that we raised in opening statements about the way in which the SPO has attempted to distort one of the underlying contextual elements of crimes against humanity in this case. We first raised this in our opening statements 3 years ago, and we have set out the position at paragraphs 625 to 630 of our final trial brief. The SPO brought this case and charged these accused with crimes against humanity, knowing full well that the ICTY had examined whether KLA members were committing crimes against humanity and had found in the Limai and Haradinai cases that the prosecution had not established a widespread or systematic attack against the civilian population. To circumvent these ICTY findings, which undermine the SPO's crimes against humanity case, the SPO has shifted the playing field and is attempting to rewrite the law of crimes against humanity. Slide 234, please. Namely, instead of alleging that there was a widespread or systematic attack directed against any civilian population, the SPO has narrowed down the target of the KLA's alleged attack, framing it as being against, quote, the civilian population of opponents, defined as people who were considered at the time to be against the KLA. In other words, the people the SPO alleges that the KLA was attacking. So, instead of assessing whether there was an attack against the civilian population, the SPO is asking this trial panel to assess whether the KLA was attacking the people it was alleged to be attacking. This type of circular reasoning is a logical fallacy known as bootstrapping. Rather than asking whether a targeted group was part of an overall targeted population, the SPO argues that every group of victims of a perpetrator can be defined as a civilian population by virtue of being intended victims of the perpetrator. This narrow definition undoubtedly helps the SPO in demonstrating that the crimes committed as part of the attack were widespread. If you narrow the definition of the alleged civilian population to the people who were attacked, it is much easier to say that this smaller population was the subject of a widespread attack. We have described this as increasing the fraction's numerator while decreasing the denominator to make it appear that a larger portion of a smaller civilian population was targeted. Slide 235. In its final trial brief, the SPO doubles down on this approach and uses new language stating that the attack, quote, was directed at opponents, a segment of the population that was overwhelmingly civilian. That's paragraph 1373. So the SPO acknowledges that it has framed the attack in terms of a smaller population, a segment of the Kosovo population. The problem is population in the contextual elements of crimes against humanity is not something that can be altered in this way. The case law requires that to constitute a population for the purposes of crimes against humanity, a group must form, quote, a sufficiently stable and identifiable group of individuals, either geographically or as a result of certain common features. Namely, a group of individuals who share common ethnic, religious, or racial features could constitute such a population. In other words, the civilian population must be defined by reference to some objective characteristics. The population in this case is not sufficiently stable or identifiable. The SPO has not defined the civilian population by reference to any objective characteristics. It is a shifting, changeable, undefined, movable collection of people whose membership depended on how they were subjectively viewed by unidentified KLA members at a particular moment in time. This is the problem with the SPO's workaround. The requirement that the crimes must be committed in the context of an attack against any civilian population must mean something. And it must mean more than an attack against the people the SPO itself claims were being attacked. By attempting to stretch the crimes against humanity definition past the restrictions of Limai and Haradinai, the SPO has gone far outside the bounds of the very contextual elements which characterize this crime. And lastly, let me come to another evidentiary anomaly, slide 236. One of the anomalies is the extent to which the SPO witnesses, particularly former KLA fighters, but also others, gave evidence which undermines the SPO's case. One of the consequences of this is that we see that the SPO is now trying to back away from the evidence of its own insider and Rule 143 witnesses. The SPO repeatedly urges the trial panel to disregard exculpatory material from these witnesses on the basis that it contradicts other corroborated evidence. Slide 238. In making this claim, the SPO misapplies the legal standard. Rule 139.6 of the KSC rules provides that inconsistencies in a piece of evidence do not per se require a panel to reject it as unreliable. A panel may accept parts of a piece of evidence and reject others. And this is part of the case law of this court. And you see the references on slide 238. So while the panel may choose to rely on some parts of a witness's evidence and not others, this case law does not stand for the broader proposition that the panel can accept only incriminating evidence and disregard exculpatory evidence. Slide 239. Moreover, the SPO rarely put its case to witnesses to challenge their exculpatory evidence. It would violate the fundamental fair trial rights of the accused for the trial panel to disregard exculpatory evidence of witnesses that was never challenged by the SPO at trial. And it would be fundamentally unfair to witnesses to hold that their exculpatory evidence was not credible because of alleged fear of a climate of intimidation in Kosovo, or because of their alleged loyalty to the accused, but where they were never confronted by the SPO and given an opportunity to answer such allegations. Any credible evidence by the SPO witnesses that contradicts other SPO evidence or testimony should be considered as raising reasonable doubt. We go to slide 240. The SPO's approach to Sokol Bashota's evidence in its final brief is a good example. The SPO states that in general, where Bashota's evidence exculpates the accused, it should be rejected where it conflicted with reliable contradictory evidence. That's footnote 5976. Again, this evidence is unsound. This argument is unsound. Assessing the credibility and reliability of his evidence requires a careful weighing and analysis rather than simple dismissal. The SPO urges the panel to reject his exculpatory evidence, including his explanation that his prior ICTY statement referencing a general staff policy to target collaborators was only hypothetical. But they offer no more as a rationale than it is exculpatory and make no meaningful attempt to demonstrate why it is patently implausible. But many factors undermine the SPO's position. Bashota was able to coherently and consistently explain why he had given this answer to the ICTY. He understood both the question and the answer to be hypothetical, a statement he repeated several times throughout his testimony. The fact that Bashota was speaking hypothetically to the ICTY is corroborated by the fact that the ICTY investigators did not attempt to obtain any details about any specific instances of the general staff having issued orders to target collaborators. showing that they also understood Peixoto to be speaking hypothetically. No professional investigator would have failed to obtain specific details of such orders if they felt Peixoto was not speaking hypothetically. Let me turn quickly to sentencing as I'm running out of time. Our starting point is that the SPO has not proven the charges against Mr. Thaçi, and he should be acquitted and immediately released to return to his family and his country. It is awkward to have to make sentencing submissions at a point where the defense is passionate about its position that the only just outcome is Mr. Thaçi's acquittal. Making sentencing submissions now threatens to leave the wrong impression that the defense accepts the possibility of conviction. We trust that you as professional judges understand the position we are in. Nevertheless, let me just take a few seconds to talk about the sentence the SPO has asked for in this case. They've asked for a 45-year sentence, effectively a life sentence. The SPO's starting point is that there are no mitigating factors in this case. This is an incredible submission from an office that knows that the Kosovo Specialist Chambers and the SPO would not even exist if it weren't for Hashim.
The interpreter kindly asked the counsel to slow down.
I see the clock is causing me to speed up. Yeah.
Repeat the sentence, though.
Okay. Yes. This is an incredible submission from an office that knows that the KSC and SPO would not even exist if it weren't for Hashim Thaçi. In the context of how few high-level international suspects are currently in The Hague or have ever been in The Hague, it is manifestly relevant and mitigating that Mr. Thaçi cooperated with the prosecutor, resigned the presidency, surrendered himself, and came to The Hague to face this court and clear his name. The SPO's claim that all of this counts for nothing is not a serious submission. Next, in asking for a 45-year sentence, the SPO relies for comparison on cases it says encompass, quote, similar offenses and circumstances. Stokic, Martic, and Taylor. Slide 245. These cases are not comparable. Stokic was convicted of extermination of approximately 1,500 civilians and the forced removal of tens of thousands of others. He played a unique, pivotal role in coordinating the persecutory campaign and took part in ordering attacks against non-Serbs. Unlike Mr. Thaçi, he did not voluntarily surrender and was sentenced to 40 years in prison. Martic was convicted of 16 counts, including murder, persecution, torture, and inhumane acts. For his conduct, which spanned 4 years, he committed these crimes with discriminatory intent, and they were directed at ethnically cleansing a territory for which he showed no remorse. Unlike Mr. Thaçi, he was a fugitive from justice for 7 years. He was given a sentence of 35 years. Charles Taylor, former president of Liberia, was convicted for his support of the RUF rebels in Sierra Leone over a 6-year period of brutal armed conflict with approximately 50,000 victims, many of them children, and many victims of rape and sexual slavery. Unlike Mr. Thaçi, he did not voluntarily surrender, and his sentence was aggravated by the prolonged suffering of the victims. He received a 50-year sentence. There is simply no comparison between this conduct and an accused like Mr. Thaçi. Rather than having a leading role in the relevant conflict, Mr. Thaçi was outside of Kosovo for much of the indictment period, trying to find a way to end it. The SPO request for 45-year sentence is not grounded in past practice or the reality of this case. Slide 246. I will conclude by saying this. At the beginning of our closing statement, I told you that this trial was a test of the SPO. We have no doubt that this distinguished trial panel will analyze all of the evidence in this case in great detail, as well as all of the submissions made by the parties. But I urge you not to overthink this. There are too many holes in the prosecution case, too many internal inconsistencies, too many illogical arguments, too many unanswered questions, too many international witnesses telling you that Hashim Thaçi is not guilty, too many insider witnesses telling you the same thing, too many documents that are missing, such as illegal orders from Mr. Thaçi, or proof that he was authoring Communiqués, if the prosecution's theory were true. No connection between Hashim Thaçi and any criminal conduct. This nearly 3-year trial was a test of the prosecution, and the prosecution has failed. Mr. Thaçi's presumption of innocence remains. It is time for Hashim Thaçi to go home. We ask that you enter a judgment of acquittal. Your Honors, thank you very much for your patience and for listening. Thank you.
Thank you, Mr. Misitich. We'll take a 15-minute break, and then we'll give you a chance to start. I know you can't finish today, but we'll get you a good start.
All rise. All rise.
Be seated. All right, Mr. Dixon, you have the floor.
Thank you, Your Honours. The prosecution's case against Mr. Kadri Veseli is most accurately described as a wild goose chase. For over 5 years since the indictment in this case, and going back even further to 2015, when the KSC was established and investigations under it commenced, the SBO has been pursuing something that does not exist, namely any evidence of Mr. Kadri Veseli's involvement in any criminal conduct. He uniquely scarcely features in the evidence in this case, let alone actually doing anything criminal. He was certainly a committed member of the KLA, who in a time of great need, as a young graduate without any professional military training, joined together with thousands of others from all walks of life and persuasions to fight for Kosovo's freedom and a future free of authoritarianism, apartheid, and brutality for themselves and their children. That, Your Honours, is not a crime. Very far from it. And in pursuing his role in the KLA with honour and courage and lawfully, there is no evidence of any worth or at all that Kadri Veseli ever participated in any criminal activities. The evidence concerning Mr. Veseli, or more aptly, the lack thereof, speaks for itself. And in our submission, Your Honours, professional forensic examination of that evidence confirms that there's nothing criminal in it. The pursuit of the impossible, that's what the SBO have been doing. They have persisted with a dogmatic faith that it'll somehow come right over time in the end, frantically chasing down every last rainbow, tilting at every windmill along the way. But they have come to the end of a long road, and they stand before Your Honours in our submission empty-handed. Their final brief, that finally is an attempt to put their case, exposes just that, as have their closing oral submissions to Your Honours this week. In our submission, it is a case against a man that has the traits of being predetermined, launched by the SBO regardless of what must have been obvious shortcomings from the beginning. There must have been fraught arguments about whether to include my client or not in this case. But once done, nothing would cause the SBO to pause and reconsider. Even as each witness they rolled out did not give any evidence against Mr. Veseli, or had never even known him, the SBO publicly showed no misgivings about their case. But privately, they must have thought it when they retreated into their offices after court, and in their heart of hearts had their doubts. And now, when the SBO finally have had to put their case in concrete terms for Your Honours, we see those doubts and manifest defects oozing from their submissions. Your Honours, just look at the first few lines of their brief, which they've regurgitated here in court again. Public statements vowed to punish opponents. Rules and regulations dictated their merciless treatment. Orders put into effect a policy targeting them. But where in the world is the evidence that Mr. Veseli did any of that, whatever that is? There's absolutely no evidence that he acted in this way. Quite the opposite. The evidence shows he was working in the KLA to prevent Kosovar civilians from, and this is using the own words of the SBO, being punished, treated mercilessly, and targeted. In particular, by engaging the international diplomatic and intelligence community abroad to understand the KLA and help save the people of Kosovo from annihilation. And, very importantly, to bring peace through a peace deal as soon as possible, for which purposes he was on the evidence, and this is not disputed, absent from Kosovo for huge swathes of time. As proclaimed by Mr. Tiga, it did not all start with the Jasari attack by the Serbian forces. Although he couldn't even bring himself to say attack by the Serbian forces or mention the Serbian campaign at all, such as, we say, the SBO's bent on rewriting the history. Indeed, it started long before that attack, as Mr. Tiga knows, because he was part of the prosecution that prosecuted that case at the ICTY. It started with the Milosevic regime's targeting of Albanians from late 1980s and throughout the 1990s through an organized system of repression and ethnic cleansing. It was in response to that policy, and Your Honours, that is a criminal policy and plan, that Kosovo Albanians grew in their resistance for survival. The idea that Kosovo Albanians were abroad plotting to come back into Kosovo, to target opponents in some kind of special war, and that they started the war by returning in March 1998, is outlandish. It requires the most blinkered of outlooks. We say it's like saying that Ukrainians started the war in their country because they planned to fight and fought against a whole-scale invasion. And when last did we hear that? Kosovo Albanians, like Mr. Veseli, did volunteer to save their country and its people. And they have had to dedicate their whole lives to that. They would have preferred a normal, peaceful life, raising their children like we enjoy in democracies, without being regarded as second-class citizens and living in constant fear. But there was no chance that was going to happen. And they had no choice but to try to stand up to the tyranny of Milosevic. And it is regarded as a celebrated moment in world history in the 1990s when democracies stood on the side of humanity and intervened to halt the obliteration of Albanians in Kosovo, having previously failed to act as decisively in Bosnia and Rwanda. So the SBO can try to argue until hell freezes over that there is enough evidence against Mr. Veseli. But that will not change what Your Honours can see now is the actual paltry state of the case against him. It is indeed the distinctive non-existence of evidence, the SPO's pursuit of the futile, that is the beating heart of the Veseli case. And it's time to call it what it is. It is reminiscent of an Orwellian type of doublethink, namely the mental ability to simultaneously hold in the mind and accept two completely contradictory points, and yet believe both to be true. It involves a reshaping of the mind to genuinely believe a falsehood. War is peace. Innocence is guilt. The SBO cannot make 2 + 2 = 5. However much the truth is denied, the truth goes on existing. Your Honours, let's then consider the SBO's final brief and oral submissions as a whole, first of all, and then I will break it down piece by piece, footnote by deceptive footnote. It's a sobering exercise, Your Honours. But looking at it as a whole first, there are 4 core issues I want to address at the outset today, and then going into the first session tomorrow. And that's, first of all, the lack of any evidence of any direct involvement by Mr. Veseli in anything criminal and the crimes alleged, and focus there very much centrally on the issue of hearsay evidence, crucial issue. Secondly, I will look at the purely circumstantial nature of the SBO's case, which is entirely consistent with innocence, we submit. Then thirdly, the fundamental imperative of justice for the victims, as highlighted by Mr. Laws yesterday in this case, without imperiling the rule of law. And then Fourthly, the extraordinary irrationality of the prosecution we have witnessed here, which shows that there's no case against Mr. Veseli, let alone one that comes anywhere near the high threshold of beyond reasonable doubt. So it's those four overall topics first, and then for the rest of my time tomorrow, I will descend into the misguided details of the SBO's submissions, breaking them down further, paragraph by laborious paragraph, with a few key examples of the gross overstatements, we say, inaccuracies in the text, and the sham sourcing of many of those footnotes. I'll only better look at a few key examples, Your Honours, otherwise we'll be here for weeks. But they will be more than sufficient to show that the entire case is debunked. I will, as Your Honours have directed, with the simultaneous filings of brief, respond to the case put by the prosecution in its brief, and then on Monday and Tuesday. I will not repeat what is in our final brief, and it must be taken that we rely on that in its entirety. First overall topic then, Your Honours, there is no direct first-hand evidence of Mr. Veseli's direct involvement in any crimes it is alleged he committed. The direct allegations are all based purely on hearsay evidence, often twice removed. The SBO could not find one witness after all this time to come to court to allege that Mr. Veseli committed any crime. They couldn't do it because there are none. This is a singularly astonishing fact. The SBO says, don't worry, Your Honours, it's all corroborated. But as you will see, that is an invention. Something just stated as they have to say so after all this time. But it's not real. While Mr. Veseli is mentioned some 260 times in the SBO final brief, none of them, only if you look at those handful of unsupported allegations, which I'll come to, leaving those aside, but none of the others show him doing anything criminal or unlawful. It's ordinary, legitimate military stuff. This is an extraordinary statistic as well. It is made even more exceptional when set against a background of several trials following international investigations going back to 1993 before the ICTY, and then before UNMIC and ULUX courts, in which many of the exact same crimes alleged in this case against Mr. Veseli were litigated, without any mention of him being involved in any of those crimes. As far as it can be calculated, we are talking about nearly 1,000 witnesses, maybe even more, I'm sure, even more interviewed, in those related cases, namely 2 cases here, 9 before UNMIC and ULUX courts, and 5 before the ICTY, with approximately 1,260 days of trial across all of those cases. No accusations against him in all of that. The sweeping breadth of these related investigations and prosecutions that could have found evidence of criminal wrongdoing, that could be brought against Mr. Veseli, have been going on his entire adult life, extending right back to the establishment of the ICTY in 1993. And yet there has been nothing criminal alleged against him until this case. Witness after witness has testified here that during the war they did not know of Mr. Veseli, or did not have contact with him, or hardly had any dealings with him, that he was not around, that he was rather abroad. He was criticized for that. After the war, when he became more known, more politically prominent, only then do a few people suddenly pop up who seek to tarnish his name, not having said anything at the time of the war about him, but only later, in the politicized environment after the war, then making shady, unsubstantiated allegations. But then none of them have appeared here in court to give that evidence to be challenged. We are left with odds and ends of pure hearsay, with no other support, that amount to nothing. I mean, literally, forensically, and as a matter of law. It's a very sorry state of affairs. In sum, Your Honours, those few uncorroborated hearsay accounts of Mr. Veseli's alleged direct involvement in any crimes are precisely that, purely unadulterated hearsay, where Mr. Veseli has not been able to confront the alleged maker and test that evidence, as is his fundamental right under the law of this court, European law, and international law. And there's no corroboration of it either. We are, Your Honours, talking here about a limited number of allegations of direct involvement, and I'll do them in general terms to ensure that it can be done in public. Two, in fact. One concerning two persons who were taken away in Reynolds, and another concerning one detainee in Klečka. And then there are a few other unconnected bits and pieces, which I'll scoop up later when I return to it. But it's those two in particular. Those are the two that the prosecution have focused on. For the very first time in these entire proceedings, we heard Mr. Halling saying yesterday, don't worry, Your Honours, Rule 144A is not applicable here. You can still convict on the basis of the untested hearsay evidence that Mr. Veseli was involved in these two incidents, because that rule only applies to witness statements as defined by Your Honours. So now, according to Mr. Halling's statement in the rule means witness statement as defined by the panel. That, in our submission, is a rewriting of Strasbourg's fundamental law and a ripping up of the KSC's rulebook and its case law. It is shockingly wrong, we say, for the SBO suddenly now to rest on such an argument. They are in a corner. They know it, and this is how they try to fight out. But that is, of course, Your Honours, no justification. Rule 144A, a cornerstone provision, undoubtedly applies to both of these instances that I'm talking about, of the alleged direct involvement of Mr. Veseli. The evidence of his alleged involvement in the taking away of the two persons comes from the statements of a person who did not testify in this trial. And his evidence was not tested. Even though, as we've heard, he could have been called as a witness, the SBO had interviewed him. His statements, his evidence, all came into evidence before Your Honours through other witnesses who simply came here to relay that hearsay, what they were told by him. It matters not, Your Honours, that the hearsay is not in the form of a witness statement as defined by the KSC. What matters is that his evidence, his statements, are untested. That's why the rule applies. As the appeals panel of this court in Sharla has recognized, that rule derives from Article 6, the fundamental article in the Convention. It derives from that article and the Strasbourg jurisprudence that guarantees the right of an accused to examine and confront the witnesses against him. The appeals panel here has made absolutely clear that that rule applies to all untested evidence, and whether that be evidence in relation to direct participation or facts constituting the elements of the modes of liability, or any other fact that is indispensable for entering a conviction. So that applies across the board: direct involvement, JCE, superior responsibility, all facts relied on to convict. That's paragraph, Your Honours, 478. The appeals chamber refers to untested evidence over and over again when confirming the applicability of Rule 144A, making it abundantly clear that what the rule is in place to protect is against sole and decisive reliance on such evidence. Paragraph 480, a few paragraphs on, in that same judgment, when referring to how this rule applies and what must be assessed, the appeals panel says very clearly, and I quote, "The central question is whether a conviction rests decisively on untested evidence." They don't say witness statements there as defined by the court. Untested evidence. The extent to which an accused has been afforded the opportunity to examine the evidence relied on in corroboration, including corroborative pattern evidence. And then this sentence, a crucial one, it's in our brief, but I will take the liberty of repeating because it's so vital in response to what the SPO now say. When one piece of untested evidence is being used to corroborate another piece of untested evidence, a trial panel must exercise caution to ensure that findings which are indispensable for a conviction do not rest solely or decisively on untested evidence. Therefore, that's close quote, this is my submission. Therefore, the appeals chamber clearly prohibits what the SPO is inviting your honours to do, which is to convict on a collection of untested, uncorroborated evidence. The appeals panel, responding to the appeal of witness 4747 and the admissibility of that evidence, your honours will recall, confirmed that corroboration, and this is important as well because it undermines the SPO submission, corroboration means confirmation or support by additional evidence or authority, or to corroborate can be defined as to strengthen or confirm, to make it more certain. To be considered as corroborative, different testimonies or evidence need not be identical, the appeals panel said, in all aspects, or describe the same facts in the same way. But the crucial point, this is what they say, that evidence must confirm, even if in different ways, the same fact. Not a different surrounding fact, the same fact that is being put forward. The allegation that's being put forward, the corroborative evidence must confirm that allegation. And that's at paragraph 36 of that appeals panel decision. Now, these are fundamental legal principles which were skipped over by Mr. Halling yesterday. He referred merely in passing to paragraphs 329 and 330 of the Shala appeal judgment to support the uncontested proposition, no one disputes this, that hearsay can sometimes be relied upon, but omitted the critical bit further down, paragraph 333. I invite your honours to look at this, where the appeals panel explicitly reinforced the requirement for corroboration, recognizing that a live witness, in other words, somebody who'd come to court and was cross-examined, was cross-examined, was able to corroborate the hearsay identification of the accused, which was the issue in that case. So hearsay identification evidence corroborated by another live witness. And the appeals panel said, yes, well, in that case, you find. Now, you don't have that as I'm going to show now in relation to these two instances. Further, Mr. Halling went on to the Kadri judgment. He referenced that, stating in terms that supported his argument. Once again, not highlighting the final paragraph, final sentence in the paragraph he referred to. This is paragraph 452. The final sentence, which makes it very clear that untested evidence requires sufficient corroboration to be relied upon in support of a conviction. That's there in the Kadri judgment at para 452. Once again, referring to untested evidence, not witness statements according to any definition. So, Your Honour, we are at this point. Is Mr. Halling really saying, to Your Honours, that this untested evidence of a person who did not come to court can be the sole basis for a conviction because it is not recorded in a witness statement that comes within the definition of the KSC? Now, he dropped in that argument. He didn't then go on to apply it to these two persons who were taken away and say, look, Your Honours, you can actually rely on that evidence. He didn't say that explicitly. And I think it's important, and I do this in the most constructive sense, to assist Your Honours in knowing what are the disputes between the parties. I think it's important that he come back and say, is he saying that in relation to that particular allegation, one of only two against my client, that Your Honours can rely on the untested evidence because it's not in the form of a witness statement, and convict on that basis alone? If he's not saying that, maybe he wishes to clarify it, then he can say, no, I'm not taking it that far. That would be the sensible approach to take. But if he's going to stick with that argument, then I've shown you, Your Honours, why it's fundamentally wrong under Strasbourg law, under the law of this court. If the SBO comes back and says, well, no, actually, what we were saying is that untested evidence is corroborated, well, then we're in a different sphere of argument. And our response then is, no, it hasn't been corroborated according to the principles of law that I've just outlined. And I'll go through that now. So we wait to hear from the SBO, because if they're simply saying it's not a question of definitions of witness statements, but really it's about corroboration, well, in regard to that issue, there are some critical principles that I've mentioned already that the SBO have to take into account, and they need to address Your Honours on that. And the first is that, yes, hearsay evidence could form part of the basis of a conviction, but it has to be properly corroborated, as the PGOK has decided. That cannot be more untested hearsay evidence. You can't just add more hearsay on top of hearsay. That's the first principle. And secondly, a very important one, which comes from 4747 appeal decision, the evidence has to go to the specific facts of involvement that are alleged. Not the general facts, but the specific facts. It's the same facts regarding the accused's involvement. More evidence about the underlying crime, generally, does not corroborate the allegation of the accused's involvement. So applying those principles to the two instances. Firstly, for the two taken away, the SBO merely rely on more untested hearsay. It was on Monday that Mr. Patch, in a brushing aside way, said that the purely hearsay evidence concerning the two being taken away was corroborated by the ability of the defense to be able to cross-examine the witnesses who told Your Honours about that hearsay. But that completely ignores that the law requires cross-examination of the maker of the incriminating statement, not the persons who relay the hearsay to the court. Doesn't matter how many people come here and say, I heard that, unless the source can be cross-examined, the SPO's case doesn't get off the ground. It does not matter that the defense can cross-examine the person who conveyed the hearsay to your court. We need to be able to cross-examine the maker, otherwise it needs to be corroborated in other ways. The untested evidence needs to be properly corroborated, full stop. Similarly, the untested statement of a co-accused cannot corroborate the untested evidence before the court, as it itself is untested. So we're back into the same cycle that doesn't assist the SPO. For the allegation, this is the second one now, concerning the one detainee in Klečka, that is also based purely on hearsay. And on Monday, Mr. Patch did not even try to corroborate it. On Tuesday, Mr. Hanning made a stab at it by saying Mr. Veseli was in the general area in the general time period, nothing specific, which even if proven, obviously does not corroborate the hearsay account, which in this case comes from W4839, that Mr. Veseli was in the specific places and committing the acts that constituted the alleged crime. The same fact as required by the law. The SPO relies on other evidence that the underlying crime was committed. But that evidence is just evidence that the crime happened. There's no dispute about the detention. That happened. But once again, that does not confirm Mr. Veseli's involvement in that crime. It only begs the question. His involvement comes from one witness, and there's no other evidence to support what that witness said. That one witness is, of course, an untested witness. Now, Mr. Hanning did not even try to deploy the witness statements only argument for this allegation, as he probably realized that W4839's account is in the form of a witness statement as defined here. So he then conveniently resorted to other arguments and says that this allegation is not based solely on W4839's untested evidence, but other evidence too. But which other evidence which shows Mr. Veseli's involvement? The SPO do not pinpoint this. There is some more evidence of the underlying crime, as I've said, but not of his involvement in any part of it. It does not matter that I could cross-examine witnesses about the underlying crime who say nothing about his involvement. In fact, they say he wasn't involved. The sole evidence of his involvement comes from one witness I can't cross-examine, and his evidence on Mr. Veseli's alleged involvement is not corroborated. It's crystal clear, Your Honours. There can be no conviction based solely or decisively on that evidence. That is the touchstone of Strasbourg as incorporated into the KSC rules and reaffirmed by the appeals panel in Charlotte. Lastly, because this may now be clutched onto, Mr. Hanning slipped in at the end yesterday. The defense had a chance to cross-examine the broader pattern of detentions in Klečka. And in their final brief, they invoked some dicta from the appeals chamber in Charlotte regarding use of pattern evidence and similar fact evidence, as we know it in common law jurisdictions, to corroborate untested evidence. But then the SPO did not apply that practically to any of the untested evidence concerning Mr. Veseli. They in fact buried this legal point about pattern evidence very deep in their brief at paragraphs 1405 to 09, but they never brought it to the fore in their brief. However, they hinted at it yesterday without developing the point. But what is the pattern that they're relying on here? The case law requires the SBO to specify it and show how it directly relates to the accused. Under the appeals panel's case law, broad patterns of detention cannot corroborate the accused's direct involvement in the specific crime alleged. It has to be a pattern or similar fact evidence relevant to the accused's actual involvement, i.e., evidence of a similar pattern of behavior by Mr. Veseli personally, of which there's none. There's no issue, as I've said, that the detention took place. The issue is whether Mr. Veseli was involved at all. The critical point is there's no corroboration of that hearsay involvement. Now, Your Honours, with respect to both of these two allegations, there are a host of other reasons why the SBO has not proven its case regarding them. The various hearsay accounts are themselves unclear, vague, riddled with inconsistencies, and really something of a dog's breakfast if you try and piece them all together. But we say, fortunately, Your Honours don't even need to go there. And in fact, the prosecution don't even get a chance to delve into that dog's breakfast, because none of it corroborates the untested evidence that's at the heart of each allegation. It's just more untested evidence, more evidence outside of any evidence that would show any direct involvement. General evidence, which even if I was able to cross-examine, which I did in some cases, doesn't go to the heart of the matter. And it's for that reason that I've spent some time of it at the outset for Your Honours, because the whole issue of the sole or decisive rule is such a central one, because it shows that the SBO failed to establish its case on these key limited areas of direct involvement. But it spreads throughout their entire brief, including in relation to the JCE and superior responsibility allegations as well. It's such a critical issue for the court and upholding the rule of law, as we've seen in the appeals chamber addressing this issue in great detail. And that's why we place so much emphasis on it at the outset. It is a lens through which Your Honours are going to have to look at the entire case against my client, particularly in relation to direct involvement. And once that falls away, which it inevitably does, we say, then moving on to look at what's left in the JCE. Your Honours will need to watch the SBO's bogus attempts at corroboration like hawks. The SBO know that in accordance with the law, they need to do this. But on the vital aspects of the case against my client, they have no way of doing so. Thus, you will encounter, Your Honours, in the undergrowth of footnotes, thousands of them, scrapings from the very depths of the barrel. Each of them have to be checked and assessed based on the applicable law, not the law as rewritten by the SBO. Your Honours would have noticed that in the SBO's oral submissions for their case against Mr. Veseli, it does really boil down to a limited number of allegations that are then just recycled over and over again. When you cut away all of the wearing waffle and guilt by association because Mr. Veseli was in the KLA and on the general staff, it really amounts to the following. The two allegations of untested, uncorroborated hearsay that I just mentioned, they can't be relied on. Allegedly being in the area generally in Ravitz in July 1998, in the aftermath of the fighting there. But no proven details of this, no proven knowledge of the actual crimes. Then in a similar way, being seen at a mine in June 1998, but the evidence shows that that was at least 5 days before any of the reported abductions, which is not even a charged crime in the case. A single document mentioning Chief Luli from August 1999, that's P709, in our submission not an authenticated document. The truth of its contents have not been proved. It is not corroborated. It does not prove anything. Even when Mr. Tiga mentioned it, he did not say why it was so significant. He showed it, he mentioned it, and I was waiting and thinking, well so? I mean, what is this used to show at that time? And then the supposedly subordinate nature of Mr. Sabat Getzi to my client as being his alleged superior. An allegation that has no substance. It's tittle-tattle that cannot be taken seriously. It is not a linguistic issue, as the SPO claimed on Monday. It is an issue of having no proof beyond reasonable doubt that he was intelligence or in any way under Mr. Veseli's command. But for a few other insignificant odds and ends, which I'll come to. I mean, that's it, Your Honours. That's what they focused on. I mean, there's nothing else. And I'll return to some of them tomorrow to go through to the extent that it's even needed. That was my first overall point on direct participation. I'm now going to move on to my second overall point, which is that the SPO, faced with those scant crumbs against Mr. Veseli, they have to now resort to an entirely circumstantial case, which the law of this court once again requires that particular caution be exercised by the court when considering it. And particularly, I would urge Your Honours to do so, because it is a most thinly veiled circumstantial case. We are at the very outer limits here of the meaning of evidence. I mean, the evidence that mentions Mr. Veseli's name or somehow is associated with him does not show any criminal behavior, let alone participation in some grand criminal plan or JCE, or knowledge of any specific crimes he could do anything about. It shows him doing usual, typical, legitimate military things. I mean, if that is labeled criminal by the SPO or used to infer criminality, well then most, if not all, of the KLA should be on trial. As with most armed forces or guerrilla fighters for any crimes invariably committed in their conflicts. I mean, it simply can't be right. If apparently bringing 7 of the 12 RPGs into Kosovo in 1997 is indicative of a criminal plan to target opponents, and here we're not even talking about the Serbian forces who were implementing the crackdown. This is those in Kosovo. Well, then, Your Honours, the net has been cast virtually across the whole sea by the SPO. And when we talk about these RPGs, I do just have to remind Your Honours that that's based on 2 unconfirmed media interviews from the same co-accused, which cannot be tested. He didn't testify. That's where it comes from. It is an illustration of how broad they cast this. I mean, what about the other 5 RPGs? Who brought them in? Are they part of this as well? The chief prosecutor concluded yesterday by saying, "It has been a privilege to meet so many people who lived through the events in the evidence, including the accused who fought for their country against great odds." Well, how can she then hold against them, my clients, that they acquired weapons to conduct that fight? This is the very clear evidence that has been relied upon against my client to claim he's part of a JCE. And yet at the same time, Mr. Veseli's brave contribution to fighting for freedom is acknowledged. I mean, this is what is fundamentally wrong about the JCE that's alleged against my client. When the chief prosecutor opened the case on Monday, she insisted no conviction is sought on the sole basis of being a member of the General Staff or the KLA. Good start. But then Ms. Lawson followed it up with, if the multiple contemporaneous public communications of the General Staff are accepted for what they clearly are, that's direct evidence of the common criminal purpose. Now, these two submissions cannot be reconciled, Your Honours. On the one hand, the SPO is saying merely being in the General Staff or the KLA is not sufficient to prove criminal participation. And then on the other hand, they are saying the statements in the name of the General Staff are direct evidence of criminal participation. The statements being relied on as direct evidence are the ones attributed to the General Staff, and they're being relied upon against the whole General Staff. It's guilt by being in a certain position. It is not individualized at all, despite the prosecutor saying that this would not happen. If it's not everyone in the General Staff, no effort is made to explain why certain persons may not be part of that JCE, why the statements might be attributed to some but not others, with any explanation as to why. Instead, the JCE is very broadly alleged to extend to seizing power and control, and I quote there, in Kosovo, which meant the violent suppression of opponents by the KLA PGOK leadership. The leadership. I mean, that is collective guilt across the whole spectrum. No clarification is made about who is in, who is out, and why. The SPO maintain that the KLA and its structures, the General Staff, the zones, the directorate, the regulations that came out, all of their statements, I mean, however rudimentary they were, they say this was the vehicle through which a mass criminal campaign was run to dominate and control Kosovo, wiping out all in their way. According to the SPO, it permeated the entire KLA at every level. Now, this essentially means, in the eyes of the SPO, the KLA as a body and its entire General Staff and leadership were acting criminally as they sought to develop their structures to be able to resist the Serb forces. I mean, it's all very well for the prosecutor to say, you fought against great odds for your country. And don't worry, I will not seek conviction on the basis of being a General Staff member or KLA member. that she is doing exactly that for Mr. Veseli, when his every action in working in the KLA and seeking to develop it, to fight those odds, is alleged as a contribution to furthering the JCE. Now, while the SPO clearly won't, and they don't say anything bad about the conventional, highly organized army which actually dominated and controlled Kosovo at the time through industrial-scale violence, namely the Serbian state forces, they have to concede that the KLA was fighting for independence from Serbia. But they even pervert that to say what was being done, namely the violent removal and suppression of all opponents, that was being done in order to achieve independence. Ms. Lawson said on Monday, logic dictates that independence would have been a prerequisite for the JCA members to obtain control. So the whole fight for independence is about getting rid of opponents. No mention of who you're trying to get independence from. The SPO uses the very language of oppression, that of seizing, usurping control and dominating, to accuse the KLA and its leadership and its organization. I mean, it's a perverse inversion of precisely the policies and behavior of the Milosevic regime in Kosovo at that time, seeking to dismantle the autonomy and control Kosovo at all costs. I mean, the idea peddled by the SPO that somehow in the forefront of the minds of the KLA as they fought and then sought to entrench themselves and fortify themselves in various pockets in Kosovo from March 1998 against that onslaught, that at the forefront of their minds was the common plan of oppressing their own people or others. I mean, it's preposterous. The idea that Mr. Veseli returned to Kosovo and moved around Kosovo to help grow the KLA so that it would be able to engage the Serb forces, and that he had in mind at that same time a plan to turn on his own people, is absurd. I mean, it's demonstrably not supported by the evidence. The SPO's theories defy logic. Why would thousands of ordinary people band together in 1998 with the Serbian stranglehold at its very peak to try to build the KLA for such a criminal purpose? They logically and reality did it to defend themselves. The theory flies in the face of, one, the evidence that we've heard, Your Honours, of the KLA being swamped and all consumed by fighting the Serbian forces on a day-to-day basis. Two, the position of the international community, in particular the United Nations and NATO, that the KLA fought valiantly against extreme odds to defend Kosovo. Three, the findings of other international criminal courts to the same effect. And four, the ICJ advisory opinion on the declaration of independence in Kosovo, in which the ICJ recognized the numerous instances of declarations of independence in the 18th, 19th, and 20th centuries, often strenuously opposed by the state from which independence was being declared, but which were not contrary to international law, including in Kosovo, as well as the international law of self-determination that developed in the second half of the 20th century. And for that you can see paragraph 79 of the advisory opinion. Now, it is wildly alleged as part of this JCE that my client planned, ran, and oversaw a criminal enterprise to identify and kill all collaborators throughout Kosovo in 1998 and 1999, directing and controlling all intelligence units in every zone and areas within the entire scope of Kosovo and the KLA, with that criminal purpose in mind. And that is alleged without any direct evidence at all in support of that claim. And yet, the SBO asks Your Honours nevertheless to find beyond reasonable doubt that all those very bold allegations are proven due to scattered fragments of non-criminal circumstantial evidence. Now, of course, non-criminal conduct can be relevant to a JCE, but I mean, you have to have evidence to show that there is criminal intent and contribution to actual criminal acts. It can't be just taking forward a war on behalf and with your organization in order to try and defend it and its people. Legitimate actions cannot be turned into a joint criminal enterprise. Your Honours, that is an appropriate time. What I will do tomorrow is finish off this section on JC by looking at the circumstances and why there's no evidence to support those circumstances.
Thank you, Mr. Dixon. We will be adjourned until 9 a.m. tomorrow. Thank you all for your attendance today. We'll see you tomorrow morning.
All rise.